is up, everybody? Welcome to Truth and Transparency. Happy Sunday night. Woo! What a week. What a week. What a weekend. I'm going to give some time for this to kick in, this notification. This was supposed to happen. I was trying to get it in, but I needed to rest up. So we are starting this on a Sunday versus the day that I wanted to start it originally. So I'll let people come on in, but this is a live broadcast. Motion in limine. A bunch of them we heard. How's the judge going to rule? Well, good thing I took really good notes. Everything is time-stamped. Whoop, just press button. Go to this, go to that, go to this, go to that. Some stuff I'm not even going to touch base on. And so I'll let that know out the rip here, which is number 1, 2, and 3, which is the inflammatory statements or evidence, and then murder, sociopath. That very easily summed up as Hitler said, listen, I'm not going to put an order out saying that you guys have to uphold your oath. You guys know what you have to do, and you're not going to commit prosecutorial misconduct. You're not going to act out of pocket. I don't need to have an order for that. Perfect. Awesome. For the first time in the motion limine in months, we finally got to hear Bill Thompson speak. So, woo. That came at the 38-minute mark of my video. We haven't heard Bill in a while. So where we're going to pick up here is at the 53-minute mark of this video, which was roughly 20 minutes into the proceeding, and it's the 404B evidence. Now, I'm going to put this on at 1.5 speed if I feel like that needs to be slowed down in any type of way. But the 404B evidence that we're going to hear about is the DeSales paper. And I'm going to tell you what I think about the DeSales paper. How mainstream media has said that this is how the DeSales paper will be used to basically make it seem like to the jury is that Brian Kohlberger knew how to clean up a crime scene to the point that this is why the crime scene does not feature him at all. That's how they're going to use the 404, the DeSales paper. It's a 2020 paper that Brian Kohlberger wrote. Now, normally you have to authenticate this. So how do we know that Brian Kohlberger actually wrote this paper? So how do we know that Brian Kohlberger actually, that this is his paper, that there's nothing fudged about it, that they just didn't take one of the other kids' names and put that on top of it? You know what I mean? Like, so this 404B evidence here is the DeSales paper. Here we go. A couple of things I want to point out.
The rule says other acts to show knowledge or plan, and so the state has expressed that they plan to use that paper. I'm sorry, I can't hear you.
That's how you can use it under.
Okay, right there. Masseth says, I can't hear you. The reason that she says that is because that was her polite way of saying, you're talking over me, okay? And therefore, I can't hear you. When I'm talking, you decide to talk. Point for Mathis to say, hey, you're a rude son of a bitch.
404. The way you can't use it is a prior term of colloquial term is a prior bad act to show that the party acted in conformity with that they had the propensity to commit bad acts. For example, as it relates to the traffic stop, I suppose the concern is, well, he committed a bad act of not wearing a seatbelt or following too closely, and therefore he's likely to commit murder. I mean, that's how the rule works. I'm confused about your statement about the prior academic paper, how that would.
Okay, so here's my question then. Do I believe that possibly, and you guys, I can say whatever I want. If I was a lawyer here in this situation, how I would have oral argued this is to say, Your Honor, we're going to object under the rules that we have, but what we're trying to, they brought this up. This is their motion in a sense that we kind of countered ahead of time only because of we want to make sure that they're not bringing in things that like, hey, like you have to let us know. And they said that, okay, we're gonna let you guys know for bringing stuff in. Well, here, there's this paper. It's a 2020 paper. We want to object to it even being entered into evidence, okay? Because what is the relevancy here? 2020, it's something from his school file. But how is that relevant to this case? How is what Brian Kober wrote on a 2020 paper for his degree, how is that relevant?
Possibly fall within 404.
Well, when in the self-authenticating pleading that the state filed about the DeSales document, they indicated that that shows that he has knowledge of cleaning up a crime scene. So our position is that we don't want to make sure that there's not some sort of in run. The same example that I will give you has to do with the Amazon records.
I don't think that we're reading the rule the same is the concern I have. And so I want to make sure I understand your position. Because what you're saying is the state's trying to use evidence to show the defendant had knowledge of how to sanitize a crime scene effectively. And that's
no. Well, first of all, what I would think that the state is trying to show is if this is self-authenticating, that means you don't need anybody to authenticate that this is an actual true copy of this piece of paper. Like, what is it? So I would be like, why can't we bring in the professor, right, to testify to, I have a class that I am the professor in, and this was part of the syllabus, right? And so this is what we required the kids to do. Just this paper alone for itself is taken out of context, in my opinion, because what the fuck? Brian just wrote this for what purpose? And then when you hear about the purpose, so why aren't we calling in, for example, why isn't the state just calling in the professor of this class and saying, Brian Kober turned in this paper for my class? Question is how are they going to, who are they going to present this to? Is the professor going to take the stand? Why would they just go through the process of going about it that way? And so how I see it is that, first of all, how is this relevant? And people can say, well, Lana, because he committed a crime and we want to show how he knows how to clean up a crime scene. Brian Kober can't speak to the paper. If he's not going to testify, who else should be testifying to this piece of paper? Brian Kober where was he when he took this test or this final? So he could have just copy, cut, and pasted everything from the online text and put it into a Word document and pressed enter and turned it in. So I didn't read over fucking any of that shit. I don't know any of that shit. I just took an online class, copy, cut, and pasted. Yes, if it's not self-authenticating, then they will have to have all the professor to lay the proper foundation. That's how it should have to be. And so I guess what I'm kind of confused about is, did the defense drop the ball here in the argument? Did they say, okay, like the way the state plans to use this is like, they filed paperwork that this is a self-authenticating document. Well, how is that? Well, because we got it from DeSales and we got it through their certificate that says this is from his school records. Okay, I didn't realize, I'm going to have to pull my school records. Then when you go to college, every single paper that you ever turn in, that somehow gets on your school record. Like papers that you turn in, they go, like they submit those and they would be then, or would this more or less be on a computer that you, that you seized, and then it was saved, and then therefore you got it from a computer, and you didn't get it from DeSales, you got it from his computer. How do we know that Brian Colbert didn't have somebody write that up for him? How do we know that Brian Colbert didn't cheat on that paper? Think about it. That's how I would think about something, is that there is no way in hell I believe that DeSales has all of his papers that he turned in, unless they were like, here, we can go back on our Blackboard online shit from Spartan, and this is how we had to upload shit, and here we can pull his name from way back in the, you know, the day, and here's all the stuff that he's uploaded. But again, I still go to the point of like, how is this relevant? How is the relevancy not over prejudicial? I would just think that, why aren't you just calling in the professor that had the class and to talk about the fact that this is what we had to do in this class. This is what I taught in this class. This is Brian's paper that he turned in. Period. I would just think the only person that could really authenticate that that's really what his work would be him. So this is my next point is that then the defense would have to bring like who's going to testify to this piece of paper? I'm just curious, who's going to testify to it? It's not just that it goes back into the room and here you go, jury, by the way, this is a paper that Brian Colbert wrote. Like, how is this going to come up in testimony?
It's one way that you can use evidence of a prior bad act that might otherwise be concerning in terms of propensity evidence. 404B doesn't exclude evidence of plan, knowledge, intent, et cetera, that's not anchored to a bad act. And so I don't see how 404 relates at all to the DeSales paper.
Well, it's our position that the way that the state is putting this in is, in essence, trying to anchor it to a bad act without giving notice of that.
I just don't think your understanding of the rules comports with my understanding of the rule.
Okay, so right there, that's Hitler's like first kind of dig at the defense is like how I interpret the rules isn't how you interpret the rules. And all that Mathis is saying there, at least this is saying, it's just like they're using this way to get this in versus trying to disclose that they're going to use it for a prior bad act. And I'm over here just like, well, who the fuck is testifying to this piece of paper? Because we know that Brian Colbert is not. So who can say that this is a true and authentic copy, right, of the piece of paper that Brian Colbert submitted in 2020 in May or whatever the fuck month it was, without giving some, like, did he get to pick his topic? Is this the topic that he picked? Was this, what was the assignment, man? What the fuck is the assignment? Okay, we just have a piece of paper here. We have a paper that was turned in. Well, God damn it, he's a criminology major. He's in criminal justice classes. We went ahead and did our due diligence over here, and we were curious of we know the professor of this class. We know what level it was. We know if it was a core requirement, if it was not a core requirement. I could tell you everything to know about this piece of paper and the professor of this class and past syllabuses that passed out in this class. I'm not revealing any of that shit because you know what? Go fucking do your own fucking work. But I wanted to know about the true context of this paper. And it matters. 100% it matters.
All right. Well, I appreciate that we have a misunderstanding of the rule. Nonetheless, that's my position. And another example of that is the Amazon records, where they're claiming that those are self-authenticating relating to purchases. And that also has not been noticed.
It's not a bad act to purchase things on Amazon.
But the state is using it, Judge, to show using it as other things to show a plan or knowledge or intent.
That is not what 404.
I personally think that they're not going to plan on using it at all. I think that they used it as a way to use the public docket. How about that? You want to hear my first thought of this? Is that this was used, and it was for the fact to be able to use the public a docket to get this out. Because who is going to testify to this fucking document?
Precludes. 404 precludes a bad act, a prior criminal act, a prior, the best term is bad, something that would suggest that it is in your character to commit a bad act, to commit the crime because you've committed another bad act, right? You abused your significant other on one occasion, and therefore you have a propensity to abuse a significant other on a later occasion. That's 404B. Evidence that somebody has knowledge or has a plan not anchored to a prior bad act isn't covered by 404. It's not precluded by 404.
It's our position that the state is trying to do an in run on that with this evidence. And that's why we raise the issue of 404B, anything that's unnoticed, not coming in as a bad act. One of the ways that we contemplated drafting this motion was because there were simultaneous filings of motions in limine, was to come up with a list of things that we were concerned they may call prior bad acts. But because we didn't know what they would raise, we raised it in this form, which is without notice. They should not be able to argue evidence is a prior bad act or do make any attempt at an in run on that rule.
So I'm not.
There you go, right there. That would have been the better way to do it. That would have been the better way to do it. And I think that it was awesome that she just says what she says there. Another way that we were thinking about attacking this, okay, was this. And then here he's like, I don't understand.
I don't understand what you mean by an in run on that in this context.
By saying that the argument about the Amazon purchase is that that was prior to November 13th, 2022, for the purpose of making a plan. And that's the argument that the state will make about that.
I mean, I think I understand what you're saying. I just think we're missing each other's understanding of the rules of evidence.
Well, I still stand by my position that the state should not be able to in run that. And I'm hearing the state say that they have no intention of doing that.
Well, I'll hear what they intend to do in terms of.
All right. In Idaho, Rule 404B of the Idaho Rules of Evidence. So this was the defense trying to get in front of this specific piece, which was the paper. 404B governs the admissibility of evidence of other crimes, wrongdoings, or acts. The way the defense is saying that this is you are going to try to use this paper as first of all, you're trying to get it in the admissibility. It's admissible. Is this paper admissible? How is it going to be admissible? Because the first thing you have to consider is it relevant? Is this paper relevant? And to me, this paper is not relevant. Why, Lana? Because this was a school paper. Unless you can prove and show, and you get a fucking professor on that stand that says, our assignment was this, and this motherfucking crazy ass went and did this shit, which was not even what we were supposed to be doing, and he's over here doing this. That may be relevant then to say, why is he doing this when he was supposed to be doing this? And the person that was grading the paper was a police officer who was I think he was a trooper actually, that ran the class. And it was for him to get feedback from a cop to say, no, this is not, you wouldn't do, you missed this and you missed that and you missed this. So generally such evidence is not admissible to prove a person's character in order to show that they acted in accordance with that character on a particular occasion. How can you sit here and say that this is not to show Brian Koberger's character? What is the relevance of this paper if that is not what it is supposed to do? However, the rule allows for the admission of this evidence for other purposes, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. How is this not to prove that this was absence of mistake or accident? Like, how is this not to prove, like she just said, preparation, plan, knowledge. Because there is no relevancy if it isn't for that. So that's what I'm trying to say is, did the defense maybe mess up in their argument there to say, we're trying to understand the relevancy of the DeSales paper. So maybe Bill Thompson has to go first to tell us how the DeSales paper is relevant to this case. Something that that he wrote in 2020, right? How are they planning on using this paper? If Brian Kohlberger is the author of the paper, usually you have to testify to what you've authored. And so how are you getting this in if it's not through Brian Kohlberger? So this is what this argument was about. And maybe
because I think that your reading of the
it could have been
requirements on them that doesn't exist under the rules of evidence, but I will listen to their.
Okay. Do you want me to go to the 404B on the video or keep it
On the
separate?
video of the traffic stop.
Okay. First of all, there's a pleading that was submitted to the court yesterday, and I have 3 copies of the video marked as Defendant's Exhibit D1 that I'll provide to the court for your review at your convenience. One for the court, one for you, one for Ms. McLaughlin. It occurred to me that it would be much easier for you to determine what you thought about this video if you actually got to see it in full. We don't need to play it in court. You can review that at your convenience. It's not our position that the traffic stop equates to a crime that makes someone capable of murder. It's our position that the traffic stop video brings in other acts that the state is trying to end run on. And I want to give you examples. In this video, things that make it more prejudicial than probative are that it provides presence in Moscow. It is at night. It is a visual of the car. That is not just the make and model. It is Mr. Kohlberger's statement that he doesn't think seatbelts provide much in the way of safety. Mr. Kohlberger's question about why they need his phone number. Mr. Kohlberger's question about how the officer reacts when people lie to him about wearing a seatbelt. If the court allows this evidence in, the state has the ability to use this to make many other points beyond identity. And the jury would have the ability to potentially seek to ask to rewatch the video and draw other conclusions that we are worried about. Such as I mentioned, him being at night, not wanting to, it being at night, him not wanting to give his phone number, which could be construed as he wants to hide his identity.
Date of the traffic stop.
Pardon?
Remind me of the date of the traffic stop.
It is on.
Okay, so something that's interesting for me is like, if you wanted someone to say like, ooh, conspiracy theorist, here you go. I was like, damn, he was on it to know like, why am I have to give my phone number up? So I think him asking like, why do you need my phone number? To me, I want to hear Duke. I would go and pull over other stops that Duke has made, and I want to see if that motherfucker is asking for people's phone numbers, or if it was just Brian Kohlberger that was being asked for his phone number from Duke. That was out of the norm. That's just me. Okay, because this pullover in August with the phone number on it, that's how they said they were able to get his phone number. And they pull him over because he was not wearing his seatbelt. That should tell you how bumping Moscow is. It's dark outside. How could you even see if I was wearing one? I want to see where this was at. Like that you could see that I wasn't wearing a seatbelt, or did you pull me over for something else and then you just cited me for the seatbelt? Like for me personally, I just want to see the whole thing just so I could see how this all played out. But normally, so in a normal case, guys, think about this. In a normal case, there is no way that they're playing this video for the jury. Normally, a guy would get up there and testify and say, I'm, Trooper Duke or Corporal, whoever the fuck he is, Sergeant Duke, and I pulled over at a white Honda Elantra at such and such time, at such and such location, and I pulled him over for a seatbelt, and he provided me his license and registration and his phone number. Now, the state's theory of this case involves a white Honda Elantra. This is where I think it gets over prejudicial. is that it's the state's theory of the case that this person that committed this crime was driving a white Honda Elantra. Okay. But that doesn't mean that that's true. That's the state's theory. And so then, is it then over prejudicial for the jury to see, oh, here's a vehicle, it's a white Honda Elantra, and are they going to then associate that that's the white Honda Elantra that's on, all these camera footages that they're going to end up seeing? Basically, if you're going to let this in, the defense is going to have to talk about all of these people in this area, especially people that know these victims that have a white Honda Elantra, also that they don't know that has a white Honda Elantra. Think about that. And if I was Ann Taylor, why do you think she's going through all that footage of all around the campus? You're going to be going through that footage to literally pull when these white Honda Elantras are on these surveillance cameras that are the campus cameras. You're going through all of that to clip through and then show that, right? No? And so what motion and limines are for is to say, like, is this overly prejudicial? Should the jury be considering this if it has nothing to do with the crime? Should the jury be should the jury be saying, well, he was in Moscow, it was at night, August 21st, he has that white car, or everyone's going to know he has this white car. And that it's one of those things like the whole Richard Allen thing. Oh, he was on the bridge. He says he was on the bridge, and it can only be him. So I would just think that the defense then is going to have to provide a ton of fucking examples of people with white Honda Elantras that are in that area driving around at night to combat that. Even if it's not the defense's theory of that white vehicle has anything to do with it, I still think that you need to put that in the brains of these jurors to say that you cannot just see somebody in a white vehicle getting pulled over on August 21st in that white car and think that has anything to do. How is that truly, like, how can you go ahead and sit in a room and say, yeah, well, let's compare this to these videos that we have. Well, you're also then going to have to beat into the jurors that don't you think that these officers that are these experts beat into their own heads to say, hey, are the clips that we have, do they match this vehicle of the guy that got pulled over on the 21st? And trust me, if the FBI couldn't match that up, you guys can't match that up. So like, these are the ways that you're going to have to do versus saying like, how about this, judge? The officer comes, sits on the stand, and he testifies to the fact that he pulled over Brian Colbert and he handed him his license and registration, and he was driving a white Honda Elantra.
No, August 21st. So it's
year?
Of 2022. So it's remote. It's
before the murders.
Yeah. Yes. Before. It's clear video of the car as opposed to the videos that are used at 1122 King Road.
Why is that a problem?
Because I think that the state, again, can use this video as an example of where you can see a white sedan clearer than you can see it on 1122 King Road in those videos.
Why is that a problem?
Because there's an argument. The argument could be made that the cars look similar.
Isn't that the whole point of it?
Exactly.
Exactly. So what is this truly? Then do you hear what he just said there? Okay, listen to this. He just said exactly. He says exactly. So then what is the point? The point is not to identify him, or the point is not to say that this is how we got to his phone number. This is how we knew what phone number he had. They tell on themselves, and so does the judge. And he's over here like, exactly. And it's just like, wait, how about this? You wouldn't try to do this in a motion in limine, right? Because they're still going to they're going to still argue the fact that when they get actually in trial, when Duke would be to take the stand and they go to motion, or not to motion, but to admit into evidence or publish for the jury the traffic stop. Objection, Your Honor, sidebar. This is what we talked about before. What is the purpose of them showing this video? They claim that it's for identity purposes. And he just says exactly to that it's not for that. He just admits that, well, isn't that the point of it? And her argument should have been like, no, the point that the state is saying that it's for is this. But your answer to what I just said is proving that you think the point of it is this. So is truly the state being honest as to what the point of the video is for? The point is that they're trying to mind fuck with the jury. And he just said, isn't that the point? You understand how fucking crazy that is? He says, isn't that the point? Why? Wait, so we should have a jury be influenced by this traffic stop?
And so it's different.
The point of it being, as I understand it, is to show that the defendant owned a white, I can't remember the name, the maker, Hyundai Elantra, and that he, as opposed to others, drove that vehicle.
Correct, Judge. And so when this video comes in, it's much more than a witness saying, you know, I looked at registration records, and registration indicated that he owned a Hyundai Elantra. When you see it on a video, and then there's going to be other videos that are put into evidence, there's a different argument to be made as opposed to someone verbally reporting a make and model. Sounds
like that makes the evidence of, I guess I'm just not tracking again under 404 how that particular issue. Now there may be the ability to cross-examine the FBI specialists about, well, this video is grainy. How can you make this?
Because this is the issue, buddy. Okay. You cannot put something in Idaho Rule 404B of the Idaho Rules of Evidence governs the admissibility of evidence of other crimes, wrongdoings, or acts. Generally, such evidence is not admissible to prove a person's character in order to show that they acted in accordance with that character on a particular occasion. However, the rule allows for the admission of this evidence for other purposes, such as proving motive, proving opportunity, proving intent, proving preparation, proving plan, proving knowledge, proving identity. And that's what they said that they were admitting this for, is to prove identity. Okay? And so you, Judge Hippler, are wrong. You are absolutely wrong. They are trying to claim that this video is needed to prove identity, and it's not. Okay? It's not. The ticket itself, what do you mean to prove identity? That you can get it in this way if you're trying to show that you're proving the identity. And do you hear all of these other things that he's saying? Absolutely ridiculous. I want to know why the judge is making the state's arguments for them. Does anybody else see that? They can use his vehicle registration. Exactly, Joker. Exactly. And that's what normally happens. It's like he is allowing prejudicial evidence to come in because that stop has absolutely nothing to do with the crime. So again, you would argue, objection, Your Honor, relevance to this being played. What is the relevance in this case? Well, it's to tie him to a white Honda Elantra. His registration does that. His what? Having Duke get up there and testify to the pulling of him over, where he was, what time he was there, the name that was given. You're trying to get more out of it. And that's not where it can be admissible. That's not the purpose for the admissibility of something like this.
Determination of what the automobile is, et cetera, to me is different than, okay, that's what their conclusion is, which you can attack. The evidence that he has a white Elantra within the years and that he drives it, it's prejudicial in the sense that it doesn't help your case, but I don't see how it's unfair.
No, it's not prejudicial and that doesn't help our case. It's prejudicial in the fact that they will be able to take this video back to the jury deliberations if this is an admitted exhibit and be able to view this repetitively. And then to use this to try to compare it to the fucking vehicles that they're going to then go and show on the night of the murder. And if that's the case, then you're going to allow us to put in all of these videos of all these perpetrators that we believe. When we get up there, we're going to ask them what kind of vehicle they drive. Jack D. Okay, Your Honor, I moved to for identification. If this is the vehicle that he gets in and out of and where he parks it at his house, play it for the jury. Now here we get to see. So now they are on the hunt. Okay. They are on the hunt to find videos of people on campus getting in and out of white Honda Elantras. I'm telling you that. That's what I would be looking for. And I'd be calling these people to the fucking stand and asking them what vehicles they own. When do you normally drive? Is this a copy of, or is this a picture of your vehicle? Like it's this is crazy.
Fairly prejudicial, which is
this is crazy. The argument here, because I would think that why are we guessing as to what the state's intentions are for? Why isn't the state speaking their intentions on what they wrote in?
We were talking about, which is 403. I haven't heard anything that's 404, but
okay. Well, they've noticed it as 404B evidence. So I'm arguing it in that context, and what other things can be drawn from this video that make it overly prejudicial. The other thing is that the state's expert disclosure by Special Agent Nick Balance lists August 21st as one of the dates that they claim that Mr. Koberger is near the 1122 King Road residence. And so the date of this traffic stop is relevant to the state for that, their ability to argue that. That also makes it overly prejudicial.
It makes it relevant. It doesn't make it necessarily overly prejudicial.
Judge, the combination of these things is that this video has the ability to be much more than what the state is claiming. The state is claiming that it proves who he is, what his phone number is, and the type of car that he was driving. And it's our position that when you watch the video, there are other arguments to be made that make it more prejudicial and therefore excluded when there are a myriad of other ways that the state can prove his identity,
You don't get
his
to,
phone
and I don't
number.
get to tell the state how to try their case unless they're violating the rule.
Wait a second, right there. But you don't get to try to tell the case how they try their case. I could not believe he said that. You don't get to tell the state how they get to try the case. No, you're absolutely right. You get to tell the defense and the state what is out of bounds, what is out, what is in. And you cannot sit here and say that my argument is wrong if that's how they're trying to bring it in. That I'm not telling them how they can argue their case. I'm showing you that they're violating the Idaho statutes. What the fuck are you talking about? They can argue their case however the fuck they want, but they cannot do it and bring in inadmissible evidence. But you have discretion here, Judge, and I'm trying to show you that this is how it is overly prejudicial. Like, wow,
Of course, I don't get to tell the state how to try their case, but I do get to tell this court what our position is regarding that evidence, and when we think that evidence is overly prejudicial and can be construed to do things that the state is otherwise saying the evidence is meant to do.
Thank
and
you.
that's the point of this argument.
They're lying to you again, Hippler, like they've been lying to you before. They're writing in a motion saying that they're going to be using it for the purpose of identifying a Brian Kohlberger. That's not what the fuck they're using it for. And she is up there trying to point that out to you, that you need to watch these videos. And you're going to see that these videos are not about that. Besides, it's you can't play any of you should not be able to play any of the volume of these videos. They are out of court statements. It's hearsay.
We ask that you exclude this video, which I will ask that it be that the marshal provide that to you, and that the state use a different method of proving identity.
Thank you.
Now, Bill Thompson, don't you think that he should have been arguing? Bill Thompson's talking more in this hearing than he has all 2 years.
Chase, the defendant doesn't seem to understand what the balancing test under Rule 403 is. There's no question that the video with the evidence, the defendant's admission of his identity, with his admission and the evidence showing it was his car, the description of the car, the registration of the car, his address, his telephone number, that's all incriminating evidence. That's why the state is offering it. The defendant doesn't like the fact that it's incriminating, but that's not.
Okay. Bill, your argument sucks. You're admitting into evidence basically his registration, and he just says, yeah, we're admitting this into evidence because it's incriminating. Admit his registration. Admit his registration into evidence. Because that's not incriminating. That's what he drives. That's what is registered to him. Why are you trying to go about it this way? That's the question.
Not a basis to exclude it. Under Rule 403, in order to exclude relevant evidence such as that, the defendant has to be able to demonstrate to the court's satisfaction that the relevance evidence, that its probative value is substantially outweighed by a danger of unfair prejudice, confusing issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Just because it's prejudicial, and just because the defendant doesn't like the fact that we can prove who he is, that we can prove what car he's driving, that we can prove what his phone number is, that we can prove his address. I mean, those are all things that tie together to connect the defendant to the homicides. Just because they don't like that isn't a basis to object to it. And so, Your Honor, we would ask.
How does that tie to the homicide?
Objection to the admission of this evidence.
About the concern within the video, as I understand it, first you have what is a 404 issue, which is a prior bad act, though one I'm sure everybody probably in this courtroom has committed at one time or another, of violating the traffic laws in some way, including by not wearing a seatbelt. And so, can you address that part of it, the prior bad act, and how the court should deal with that? And then also, I am concerned with the issue raised about the communication between the officer and Mr. Kohlberger, for example, his asking why they need his phone number. That could, I think, be unfairly looked at as if he has something to hide, which would be, I think, unfair. And so I am concerned about that.
They might agree to mute that
I
video.
appreciate Your Honor's comment. I think when you review the video, you can the court will be able to put it better into context. The state certainly doesn't intend to argue or suggest that the colloquy or the discussion between Mr. Kohlberger and Deputy Duke somehow showed that Mr. Kohlberger was a bad criminal type of person. We certainly are not suggesting by any stretch of the imagination, although the defendant alleges it in their response to the state's filing, that the fact that the defendant was apparently speeding without wearing a seatbelt somehow means that he is guilty of murder. I mean, that's preposterous.
Okay. Bill Thompson left himself in there when I was writing my notes. I said, you mentioned the word speeding, and I go and I mentioned that right there, and I write it down, and it's like, wait a second, at 4:20 in 40 some seconds when the car is speeding away, okay, and he doesn't put on his seatbelt, right? Because he hurried up and took all of his clothes off and wrapped them all up in some fucking bag and then put it in the car, and then he got in his car naked, and he didn't even bother putting on his seatbelt, which he normally doesn't do, right? That's what you're, yep. He normally doesn't put on his seatbelt. And then he sped away like he normally does, just like we caught him on that when Duke was pulling him over or whatever. If you don't think that they're going to say that shit, man, they're going to say, and once the genie comes out of the bottle, right, it ain't no putting it back in.
Concept. And the defendant seems to have backpedaled from that before Your Honor just a little bit ago. The state's purpose is to elicit the vehicle and connect the defendant to the vehicle, the description of the vehicle, the defendant's name, of course, his phone number, his address. That's what the state's interest is. And the state, as it views the entirety.
Okay, so I want to know how you cannot just put down or rather have Duke up there and he would testify to the speeding ticket that he issued or the seatbelt ticket that has all of that shit on there, right? What he just said, what his argument just said was that we're just looking to do this with it. And then if Judge Hippler wasn't biased, the response to that is, well, doesn't the ticket do that? Doesn't the ticket do that? So you're wanting more out of this stop than the identification of Mr. Kohlberger. Do you understand that? That's the argument. Is that right there, he says this, and then if you're going to not be a biased judge, you should say, well, based off of that, couldn't you get all of that off of the license registration and the ticket?
Of the relatively brief traffic encounter we don't see anything incriminating or making the defendant a bad person out of that. Now, of course, Your Honor will need to see that and decide if its view is different. But we don't see that as being prejudicial. We certainly are not trying to argue some sort of propensity that because he questioned about, why do I need to give you my driver's license? That all of a sudden that makes him a murderer. I mean, that's beyond a stretch of imagination. Does that answer Your Honor's question?
Thank you.
Thanks, Judge.
Okay, so he says, thank you. So where was the pushback? Like I just said, why wouldn't he just be saying back to him what I just said? Well, can't you do all of that with the ticket? With the testimony of Duke?
Response.
Fucking has nothing to say about that.
Ms. Mathis, back to
If there is a way to, clean this up with regard to this, and that would be to not allow the jury to see the video, to have the officer who made the stop, testify about the stop, testify about the identification, make and model of the car, and the phone number. The argument that the defense doesn't like troubling evidence could be said about every single thing that the state wants to proffer in this case. This is a highly circumstantial case. And so every little fact that is circumstantial is going to be relied upon by the state. And so we have to look at a critical eye with everything that's coming in before this jury to see what the cumulative effect.
She fucking nails it. Right there. I mean, you want to give an award out who did the best oral arguing in this proceeding? Hands down, right there. That's your girl. That's who did the best oral arguing of the whole day. Both sides. Right there. This is a highly, highly circumstantial case. And when you hear that, if you're the judge, you think to yourself, yeah. I love that. Someone said, you like that backpedal, Bill? No, she just shoved it down his throat.
Is going to be of that. And so it's not that we don't understand that his identity is going to be proven. As I argued, there are a myriad of ways for them to bring in his identity, but to add all the other components that you will see in the video do much more than just prove that he's Brian Koberger with a phone number in a Hyundai Elantra. Thank you.
Okay.
With regard to this motion and the 404 issue in general, the standard for the admission of evidence that falls under 404 is that the court determined that there is a factual basis by which a jury could find more probable than not that the prior act, if you will, occurred, that the prior act is relevant for a purpose other than propensity, such as identity, and that a balancing test under Rule 403 would not otherwise preclude the evidence, i.e. that the unfair prejudice does not substantially outweigh the relevance. When it comes to 404B evidence, and that's how this was noticed and brought to the court's attention, which is the framework that I'm looking at, 404B does not apply to just any prior act. It applies to prior bad acts, other crimes, other wrongs, not other acts of benevolent or non
He's
type
wrong.
that doesn't implicate propensity. And so I don't see the concerns that were outlined by the defense, for example, related to the Dell's paper and things like that, that's a 404 analysis. That's simply a 403 analysis, which is there unfair prejudice or other concerns that substantially outweigh the relevance? And there isn't the same notice requirement for that issue as there is for 404B. And so I don't see this as the examples raised as a quote unquote end around at all. And so the state does have a notice obligation when it does come to prior bad acts that it may seek to introduce. At this point, they've only identified the one, which is the traffic stop. The Rule 404 requires notice in advance or during trial when the state is aware of the need for it. And so, I don't think we can say that the shot clock has run out on that at this point. But certainly, as soon as the state is aware of the likelihood of the need for that, they have that obligation to seek that. And at some point, prejudice to the defendant in terms of lack of notice will upend the state's ability to use it if not properly noticed. So, as a general matter, the state is required to provide that reasonable notice set forth in 404B. With regard to the traffic stop, the concerns identified by the defense related to, well, let me go through the 404B analysis. It is technically another prior bad act, which is the sort of colloquial terms used by the courts in describing 404B evidence, in that the defendant was stopped for violating traffic laws and ordinances. I think there obviously is evidence by which a jury could conclude that that conduct occurred. The next question is it relevant for a purpose other than that he has a propensity to violate the laws? I think in this case, there clearly is a other purpose besides that, which is identity, which is ownership of the automobile that
Now that's wild. That's wild.
is alleged to be a suspect automobile and control over that automobile. And so I think there is a relevant purpose for it. And the next question is that relevance substantially outweighed by unfair prejudice? The fact that it is more powerful evidence than perhaps a simple description by somebody of DMV records doesn't make the evidence unfairly prejudicial. It just makes it more effective.
You hear that? It just makes it more effective. It doesn't make it overly prejudicial. It just makes it more effective. You guys understand this. I could not believe when he said this. Do you understand that everything that would be overly prejudicial would be effective? That's the whole point of the word prejudicial. Effectiveness. Like that blew my mind. Normally what judges say here is, state, I know what you're trying to do here and how you're trying to use it. You're going to have to go, I'm not going to allow you to use it for that purpose. Like, if you want to compare Adam Montgomery's case, okay? Because I think of motion limines all the time. I always fucking think of his case. Fucking bastard. Piece of shit. I think of all the stuff that was kept out, okay, in that piece of shit's case. And it's because it's the rules. Like, anything that's prejudicial is going to be more effective. If I get to use prejudicial shit, of course it's going to be fucking more effective. So I just, unbelievable that he said that on the record. Unbelievable.
that is not the type.
Like, you'll be able to use that down the road as far as discretion. Like, this guy's discretion here is
Of unfair prejudice that the rule contemplates. And I don't, frankly, track the defense's argument with respect to that. And so I think as a general matter, the traffic stop is relevant. It's not substantial. I think there is zero danger that the jury will conclude that because he didn't wear a seatbelt or sped, that he therefore has a propensity to commit murder. I just can't imagine any reasonable person coming to such a conclusion.
That's not what it's not what they're going to argue. It's what they put in a probable cause affidavit about speeding away at a high rate of speed around the corner, and you should exclude
The
it.
jury will be instructed that they may not use that evidence as propensity, may only use it for the relevance of things like identity, ownership, and control.
So he says it right there. They're only going to be able to use it for that. So he's going to have to look at this video. We don't get to see the video. We don't know what it says, but he's going to have to look at this video and determine. You're going to see what the state's going to be trying to do with it. And if you want to like hide around the fact that you don't think that that's going to happen, but it's for the purpose of identity and what he just said,
there are concerns that were raised, however, and so while as a concept, I think the video is appropriate under 404, or notwithstanding 404B and 403. I do want the video potentially, I'll look at it and it may change my mind, but just from the description, I am concerned about some of the interactions with the officer that was mentioned that,
I'm surprised that he just didn't say here, instead of fumbling around like this, that he just didn't say, I'll take it under advisement. I'm not going to lie. Like, I cannot believe that he just fumbled around like this.
Questioned why the police needed his phone number. That the officer said something about how he views people that don't wear seatbelts. I don't think any of that is relevant. And it does potentially create some some danger of unfair or unnecessary prejudice. So I think it needs to be.
Okay, so are they trying to go with the admission of the dash cam? Are they trying to go with the admission of the body cam? Are they trying to go with the admission of both? Are they going to do like a split screen here?
Redacted to exclude those kinds of things and have the video that shows his vehicle, that he gives the registration, that identifies it as his, that he.
Did you hear how he said that we're going to show the video? We're going to show the video that shows the vehicle. That shows the vehicle.
His answer to what, not the stuff leading up to what his telephone number is, but if he gives the telephone number, the answer, what the telephone number is. I think that's what we ought to see, and probably not much else. So I'd like to see that before it's played to the jury, and we can work on redacting.
He walked that back a little bit there.
Counsel, and within the confines of my rulings, they can raise any concerns they have.
Thank you, Judge.
Next up. Well, it's kind of what I said about redacting the, like hearing anything. If you guys watched the Dell case, how they didn't have people talking in the body cams. So.
All right, let's talk about who is going to be in the courtroom amongst the victims and the defendant's family in general, in terms of reserved seat. I'm not as concerned about the reserved seat part. We can address that at the pretrial conference down the road. I'm more concerned about the ability to be in the courtroom, notwithstanding an exclusion order of the court of witnesses. So let's address that issue.
Ashley Jennings.
The state filed this motion in order to seek clarification of the court's definition of immediate family member pursuant to Idaho Code 1950-3061B. As you know, that specific code section doesn't give us a definition of immediate family member. The state has given a proposed exhibit, State's Exhibit S1, which we think are justified as being.
Boo! And the crowd goes wild. Boo!
To that list, and we would just ask the court
We are just booing Ashley Jennings, guys. Come on now.
to issue an order to that effect.
Defendant's motion, so I'll let them address that first.
Submits that by simply placing our client's family on its witness list, that is enough to warrant exclusion, and further that they may call family members. I want to note that they have not subpoenaed them, the state's attorneys have not interviewed them, and they know that Mr. Koberger's family does not have any interest in helping them. They also know from watching all of Mr. Koberger's video visits how much his family loves him and supports.
Think about that. All right, think about this. They have been watching, okay? They have been watching all of Brian Koberger's family visits. Okay. Wow. You know, it's got to be a shit ton, right? They have not interviewed one single family member. And yet all of his family members are on their witness list, the state's witness list. And basically the defense is saying that you're putting them on the witness list to exclude them from the courtroom. Why are they on the witness list? How haven't you talked to them yet?
supports him, and that he is absolutely dependent on them, having been in isolation for almost 2.5 years. And by the time we get to trial, it will be almost 3 years. His parents attend every court hearing, and the only reason that they are not here in person is that they do not have the money to fly back and forth from the East Coast. If they had the financial resources, discretionary. There's a reason for that. The reason is that the court must balance Mr. Koberger's constitutional right to a public trial with other needs of the case. In the United States Supreme Court in Ray Oliver in
Like, I couldn't even believe that this was even having to be
1948,
said.
State v. Sams in the case over this issue, the court held constituted constitutional right overturned when the accused was money. These are videotaped. There's the state in discovery and expert opinions.
Look at how bored he looks.
For Mr. Koberger to have his family sitting behind him. We've also
The best argument that she made, and it's so true, is that I was there. I witnessed it in Delphi. Every single one of those jurors, every time they walked in, they were literally, their heads are going like this in sizing up who is there, and they're taking note of it. And they would always look over and to see if Kathy Allen was in that courtroom and who was sitting with Kathy Allen.
also asked in our motion that the court address decorum, since the court's going to be issuing an order. As we pointed out, there's been some history in this case with clothing being brought into the courthouse that's pro-death penalty and pro-fire.
So I'm all for First Amendment rights, like, freedom of speech and everything like that. And I also think that I don't believe that the families are going to be, acting like fools in there. I think that they're just doing their job by saying that, but you can say whatever the fuck you want outside the courtroom. You can wear whatever the fuck you want outside the courtroom. And I think the people that would do that wouldn't be doing that in the courtroom. So I just think that they're saying this for they have to.
There's no place for that in this courthouse at all during these, clearly.
In order to exclude Mr. Koberger's family.
All right, here we go.
And no,
Here we go.
All right,
Here's
Ashley
Matt.
Jennings is going to do the argument here for the state. How can you even argue this? The parents should be in the room.
Your Honor, the state trusts that this court will enter your own standards of decorum for the courtroom, and the state will advise our witnesses and immediate family in accordance to those instructions, and we expect that they will be followed. Regarding the defendant's family, in no way is the state intending to use its subpoena power in order to exclude Mr. Koberger's family from the courtroom. The state's not aware.
Then right there, you would say, in fact, we have no problem with them being in the whole time. We have no problem with them being in the whole time. But they don't say that. Why? Why wouldn't they say that?
Aware of any authority to support this argument that the defendant has a Sixth Amendment right to have his family in the courtroom. He, of course, under the Sixth Amendment has the right to a public trial, but that's not his choosing of who is in that courtroom. Totally understand it's within your.
So then, like for example, like the Delphi case, there was 10 seats for the defendant's family reserved. You didn't have to be in any line. And then there was, I don't know if it was 20 because, the two victims. So it was 10 each. So it was 20 and 10, which I think is fair, and that's how it was in Delphi. Like you didn't have to stand in line if you were the family and you had one of those reserved spots.
Discretion to allow certain immediate family members in the courtroom to support
The
Mr.
reason
Koberger.
you can't simply take up whatever family members you may need to testify in your case in chief right at the beginning. Other than, obviously I know you have a narrative on how you want to lay these things out, but what I will tell you is both sides ought to get used to the idea that with a 3-month trial, the trial schedule will not be held hostage to your narrative. In other words, we'll be taking things out of order, stopping witnesses to put another one on to make sure we get through them, and picking them up again. And so is there a reason you couldn't?
Okay, so that's interesting to me that he said this during this case, because I think the narrative here is really, really important. When it's a circumstantial case, the narratives are very, very important. Your timeline and flow of things, I would think, are really, really important. I think that this would, if he's being I think who that would affect the most would be the state. Because if he's like, oh, well, you couldn't get this person in here today. Well, we're not going to just not have a court from noon on, So who do you have next up, Miss Jennings? Who do you guys have up next? There's not going to, we're going 9 to 5. That's kind of how I see that, right? And so but then again, he makes these fucking statements and they don't mean shit, because guess what? In this proceeding, he doesn't give a fuck about his deadlines. So fuck you and fuck your deadlines because they don't mean shit. Because we saw it right here. But if anybody's going to be penalized about that, I'm telling you right now, or feel, it would be the state, because they're putting on this, it's their burden to present this case and to be putting and presenting it in a cohesive way for the jurors to understand it. Now, they can't even get to Brian Koberger until, if you mess with that with them, woo, that's going to be, woo, that'll be interesting.
Call whatever family members you need right away.
Well, I will say, we have no intention of calling all the family members. We have the intention of calling a few of the family members to serve certain cases.
Well, a few is a two. A few is more than 2, 3. A few. Who?
I can't think of a reason that we couldn't. Obviously, it's not ideal. It's completely out of context. It's out of order.
This is like a gumbo.
She says it's complete. Now, I want you guys to pay attention. I stopped it right at the right moment. Okay, look over here. Bottom screen. There's Bill Thompson, perfectly sitting fine. Starting to come into frame is Josh, new signee. He comes over and he wants to lean in and he wants to tell Bill Thompson something. And so clearly something that he wants to say, it has to do with this. I'm over here probably thinking Joshua was just like, dude, just tell them they can sit in there. We don't, like, they can just be in there the whole time. We don't want to, we would never, and he's experienced with this, right? So as soon as the judge is saying something about, well, can't you just put them at the beginning of your case? Well, if that's the case, we would just rather assume that if we have to put them at the beginning, that we would just rather have them be in there the whole time, and then we'll place them where we want. And they can just be, they can be excluded from the sequestration from the courtroom. That's what I think Joshua is going over to tell Bill Thompson. That's my opinion. Now watch.
You are going to put all the pieces that go into the pot.
So Bill Thompson sees that he's coming over.
At the end of the day, the jury's going to decide
There's Josh.
super not from the state's perspective. And so I think we get too.
You see Bill Thompson go like this, like he was listening to what he was saying, because I think Joshua was asking, who are these witnesses? And just, you don't want to just concede that. And then that Bill Thompson does this like little, like he's like contemplating or thinking about it, like, he's like, it's not a big deal.
Obsessively stuck on the idea of exactly the order these things need to come in, right? And so I'm not sure why you couldn't call the family members you need up front, and then we take away this concern. I can certainly understand from the defense perspective the need and desire to have.
My question is why aren't you just saying they're in? I'm gonna, like, they're in. Why are you even telling Ashley Jennings any of this? Say, I'm going to allow them to be in. It doesn't matter where they're at in your case.
The defendants support family here in the courtroom.
I do too. And I guess my preference would be for that, even though it would be out of context and interfere with the state's preference of how to present its case. And I think I do take issue with the defendant being able to direct how the state presents its case to a jury.
She is fucking arguing stupid shit right here. And I'm telling you, that's what Josh went over to tell her. Like, dude, do you not know how to pick and choose, like, your battles, girl? Like, how is the defense controlling anything here? The defense isn't dictating shit. It should not be any sweat off your sack to have them in there. You're coming across as a raging second day period fucking piece of shit.
However, if our options are the immediate family members staying in the courtroom and hearing all the testimony of other witnesses versus calling them out of order, it would be our preference to call them out of order. Thank you.
Because they don't want that. So they're basically saying that if the Kohlberger family was to hear any of this testimony with anything in their case, it would influence them. Dude, what the fuck do you think these Kohlbergers know? Blew my mind.
She's a damn
I knew
nut.
that the state's position was that there's no case law to support our position, which is why I just went through several cases where it is his constitutional right, one, for it to be public, and there are cases, as I referenced.
Constitutional right is not absolute. It bends to, for example, rules of evidence and other rules. And I'm not aware of anything that says a court can't use the exclusionary rule where in good faith, a person who is otherwise entitled to be there, including family members, have to be excluded for some period of time.
And that is why I specifically talked about the point that it is discretionary for you. And there's also, Judge, a level of humanity that I hope that you take to serious heart for his family, who is absolutely devastated and dealing with things like headlines that they're going to be called to testify against their son with these types of communications that are happening.
I loved this. It was like, hey, mainstream media, you need to shut the fuck up. You're wrong and you're spreading lies. Okay. Spreading lies. So right there, if you can't use this little clip to see, hey, please end this charade, Hippler.
And so we're asking that you use that discretion and that you find that humanity. Thank you.
I think he's going
This
to.
matter under advisement. The defense raised some cases. I want to read those.
Okay.
The one thing that the defense is concerned about is exactly the testimony and the witness who will be
All right.
using the.
Let's really hone in here.
Let's talk about what I hope we come to an agreement is not an issue, which is the IGG stuff.
Okay. He said, let's talk about something that that is not. Look at Ashley Jennings' smile right there. And I was like, I gotta see how this
What I hope
happened.
we, come to an agreement is not an issue, which is the IGG stuff.
If I may start, and they're
Yeah, I think there are three motions. One is the improper expert testimony of Middleman, who's related to the IGG. The defense, and that's the defense motion. Defense motion regarding IGG evidence generally, and then the state's motion regarding IGG.
Yes, good morning. You're right, Your Honor, that we have essentially, I think, an agreement with the state as to their position and our position being equivalent at this point for different reasons. And I believe that the state is willing to proceed without Dr. Middleman, therefore making that motion moot, and that they will proceed with using the generic term or the generic evidence of a tip leading to the identification of Mr. Koberger. The only issue that we have is how that tip will be presented to the jury. The one thing that the defense is concerned about is exactly the testimony and the witness who will be testifying to the tip. And we want to make sure that nothing that is said by that witness implicates another source. And by source, I mean someone like a witness who called with a name or some other way of identifying Mr. Koberger by name as a possible suspect. The state, in their response.
Right there. Right there. She says, we're in agreement. They said that they're going to use some way to talk about Mr. Koberger, and we're just making sure that they're not going to basically say something that's not, that didn't happen. That didn't happen, right?
To us said, well, we have lots of other evidence, and they have lots of other evidence they intend to produce. But the only thing that identified Mr. Koberger that set them on a train or a trail to charging him was a genetic genealogy. So we just asked.
Well, I don't know if that's a fair statement. I think
Why is he even commenting right there? I don't think that's a fair statement. What the fuck is he talking about? Yes, it is a fair statement. It's the truth. It's not like it's not a fair statement, you guys. He is still dying on this hill. They wrote it in their own motion. I couldn't even believe this shit. What is he talking about? The state says we got to Brian Koberger through fucking IGG. It's in the motion right there. If I am Shug Tits Barla, if I'm Bicca here, I am saying, Your Honor, in their own motion that they just filed for this motion limine, their first sentence is, let's fucking read it. States motion in limine to exclude IGG. it's an 8-page motion, and it says the name Brian Kohlberger first appeared on law enforcement's radar in this matter because of IGG, and IGG has been the subject of much litigation in this case. You guys want to see it, or do you believe me? That bucket, I want to see it. Show me, Lana. I'm from the show me state. There we go. I don't think that's a fair. Okay. State's motion in limine. Investigative genetic genealogy. The name Brian Kohlberger first appeared on law enforcement's radar in this matter because of IGG. Period. End of story. Okay. They wrote it themselves. Period. It's right there. So now bring back in home tits here. Hippler.
Train or a trail to charging him was the genetic genealogy. So we just asked.
Well, I don't know if that's a fair statement. I think the thing that led to them investigating him was the investigative genealogy. I think that's
What did she just say? Why is he fucking up the... Listen to what she says.
a witness who called with a name or some other way of identifying Mr. Kohlberger by name as a possible suspect. The state, in their response to us, said, well, we have lots of other evidence, and they have lots of other evidence they intend to produce. But the only thing that identified Mr. Kohlberger that set them on a train or a trail to charging him was the genetic genealogy. So we just asked, well, I don't know if that's a...
The only thing that set him on a trail, set him on the trail. What does that mean? That means the first thing that set him on a trail to Brian Kohlberger was the IGG. That's what she says. He says, well, I don't think that's fair.
I think the thing that led to them investigating him was the investigative genealogy. I think that's what led to the only thing that led to charging him.
I apologize. You're true, right? It was what they led them to investigate him and ultimately charge him. But
I would have never said, you're right, I apologize, because she didn't say anything wrong. Okay? The way that she said it was IGG is what led them on a trail to charge him. That's a fact. But why is Hippler even speaking?
I think that the court could issue an order or at least require the state to make a proffer exactly how they're going to do this.
Right there. I wanted to hear that all over again. So we want an order asking the state to proffer on how they're going to do this. Because we know that none of this exists. There's nothing that exists. So we are asking for an order, okay? We're asking for an order that the state can proffer on how they think that they're going to tell the jury how they got to Brian Kohlberger to start investigating him without mentioning IGG.
The reason I'm here is because I've done a lot of cases with DNA evidence. And the last thing I want is a repeat from a case I tried many years ago, which was a cold hit, where the state simply introduced a quote tip through testimony of a police officer. And the first question the jury asked was, what was that tip? And that is not, we do not want the jury to speculate. It's not our job to tell them how to do that, but I think the court has to be vigilant.
I certainly could anticipate that being an issue in terms of the jury's curiosity, right? Depending upon how compelling or not compelling the other evidence may be viewed by them. And so it may be that you want to come up with some instruction to the jury that basically says, you know, we're not going to tell you what that tip is and you don't need to consider it.
No, that's not what we're saying at all.
Is that an invitation?
It's an invitation for you two sides to work together to try to solve this conundrum in a way that you both can live with.
Okay, well, I accept that.
Right there. So she's like, I accept this invitation for the two sides to come together to try to figure this out. And I accept that invitation to do that. Okay. Just because you accept an invitation to do that, that's how you should state it. That does not mean that there is going to there's not going to be a resolution from that. Because I promise you, this is the smoking gun that the defense has. This is why they did it this way. Okay. You're not going to blow up an opportunity to talk about how shitty the FBI is by violating DOJ policy and doing all this other shit, that you could show that, well, if they did that, then look at how shitty they are then again too, with the FBI doing the burying the 7 minutes. You're not going to blow your leg off. And so moral of the story is that the defense is not going to allow, I'm telling you, the state to make up some generic tip and say, okay, yeah, that's fine with us. No, they put way too much work into it up to that point to eliminate how they could ever mention Brian Kober without the IGG.
Invitation, and I assume the state also will be willing to do that. I don't know if anybody has any comments.
And what she means,
sometimes not
what she means is, I'm sure that the state will be willing to talk to us. Okay.
context of DNA, but we will have, as an example, a probation officer who does a home visit and searches somebody's property without a warrant or other right, because they have that ability on probation, because the defendant will have waived their Fifth Amendment rights as a condition of probation. And sometimes then we want, we'll have to have the probation officer testify in a way that doesn't necessarily tip the jury off that the defendant was on probation, which would be a 404B issue. And I've seen, without some explanation to the jury, when we use those sort of generics or whatever regarded the search, that can cause curiosity of the jury and then get sidetracked. And so we will frequently use an instruction to the effect of, law enforcement's search of the backpack has been found to be lawful, and you should not consider or concern yourself with that, right? And so it's basically telling the jury, don't speculate about this point or how we got to this point. It's not important, and you're not to do it. And I think that generally.
This is how, when I heard him give this explanation, I said, holy shit, he is so wild right now. Bigga's just standing up there like, say whatever you want. That doesn't mean that they're like, okay, yeah, that sounds great. That's what we're gonna do in this case. What the judge is describing here is two sides stipulating to that shit. He's showing an example of two sides that stipulated to that, of what he's coughing up as, yep. So we have an issue here where based on person was on probation, and so we couldn't bring that up, but that's how we were able to search it. But it was lawful, but we couldn't mention he was on probation. Well, who the fuck was his attorney for the defendant? Okay. Think about it. Probably a public defender that made some shitty ass fucking deal and said, fine, we'll stipulate to it. Fine, we'll just stipulate this because they don't want to do their job. What he is comparing is fucking grapes to literally zebras.
Causes them to back off that. And so that's what I'm suggesting.
No, absolutely not.
Will do. Thank you.
What?
That's all I have to
I
say.
didn't mean to cut you off.
No, that's all I have to say. That was the only concern that was left for us.
Wait, what?
I was curious what the defense meant in their reply, where they said that the testimony about the tip should not falsely suggest other evidence, and I still have no idea what that means. But we are happy to engage in a discussion about a jury instruction like the court outlined. I will comment that it seems like it took a long time to come full circle, because we're right back.
When Bill said this, he's like, I'm confused as to what the defense means by, well, if the prosecution is going to suggest to the jury that they got to Brian Kober some way that they didn't, that's not going to happen. And we welcome this argument. Bill Thompson says he has no idea what that means. He is a fucking liar. He knows exactly what that means. How could a 2-year-old not know what that means? You're not going to elicit testimony that's false from anyone on the stand on how you began to investigate Brian Kober. Use your fucking probable cause affidavit. But he wants to throw this out there like he's just so confused. He's not confused at all. He's
where the state started a long time ago with a lot of court effort invested in dealing with hearings in the interim. I appreciate the court's diligence with that. And I think also for the record, there were some pretty serious allegations, ethical allegations made by the defendant in its motion in limine number 11. Those were factually rebutted very clearly in the state's response. I just want the record to reflect that the state maintains we did nothing ethically wrong with this, but we're satisfied with where we are right now.
You know, sometimes we litigate.
We're satisfied with where we are right now. Do you want to know where they're at right now? We're satisfied with where we're at right now. Where they're at right now is that the defense and the prosecution are going to have conversations because the judge offered them an invite to talk amongst themselves to see how they could possibly come up with, to stipulate to a way that they would be able to introduce Brian Kohlberger to the jury. That's all. That's where they're at with that. And so he's satisfied with the fact that they're going to have a talk.
Issues for purposes other than evidence at trial, right? We do it in terms of constitutionality of searches and other things, and that's all okay. I certainly have not made any finding that the state has done anything inappropriate, and so nor have I seen anything to suggest to me that that is the case as of this moment right now, at least, as it relates to that.
As it relates to that, that's because there's another big issue.
To me, this is a practical problem, regardless of the reasons you are in agreement. The important part is that you are in agreement. I suspect what the defense is suggesting, I think, trying to read the tea leaves, is they don't want an implication that there was some other evidence related to a tip or specific to Mr. Kohlberger that put him on the radar, right? And so I think that's just where you come. I don't think, for those purposes, we're suggesting that the state can't present its evidence about the car, suspected car, about the defendant's whereabouts on the night, et cetera. Those are
I couldn't even, dude, I'm going to rewind this. This is insane. Listen to him try to struggle when, I don't know if it maybe went off in his head here, but he gets it. He's like, we're making sure that the defense is making sure that the state isn't going to talk about somebody else, everything we've been saying, right? And he's like, but that's not saying that the state can't talk about, and then he wants to list these things. And I'm just like, holy shit, he's not, because what do you mean? You're listing things off. Just because you're listing these things off, how in the fucking world are you going to say that just because you're listing these things off that you found around the crime scene, or how did it get back to Brian Kohlberger without you saying anything to do with IGG? It's impossible. There's no way to do it. This is a fact.
I suspect what the defense is suggesting, I think, trying to read the tea leaves, is they don't want an implication that there was some other evidence related to a tip or specific to Mr. Kohlberger that put him on the radar, right? And so I think that's just where you come. I don't think, for those purposes, we're suggesting that the state can't present its evidence about the car, suspected car, about the defendant's whereabouts on the night, et cetera. Those are
There's nothing.
The defendant's whereabouts on the night. How do you even get to the defendant's whereabouts on the night if you don't have the defendant? This is just wow. And this is Bicca. As long as he says the IGG is out, we are golden. Unbelievable. Like this is crazy.
Together after the fact, right? I think it is important to develop a narrative that doesn't suggest, for example, there's some fact witness who may have heard a confession from the defendant or have witnessed the defendant that led to the tip, right? And so I think it's important how that's presented, and hopefully you can work that out. And if you can't, we'll revisit how to do it.
That's what's going to happen. They're not going to go to
Hopefully you guys can work that out, because if not, then we'll revisit that. Okay. Well, and that's why I said the most important thing is that there's an order that the IGG is out. And from me being like literally watching this with all of you guys, I want to wait until Hitler puts an order in that says that the IGG is out. because the state needs to put in some emergency motion. I'm telling you, because there is nothing else. There is nothing else. And they should have just bit the bullet with everything that was.
Work it out. They're going to be revisiting this.
I've already spoken with the investigators to develop this, is to have probably Detective Payne, who was one of the leaders and lead investigators, to simply testify that they received a number of tips, that around December 19th, they received a tip. Following that tip, they took these steps. That's what we're contemplating at this point.
Do you see Ann turn to her? Okay, watch this. Watch when Bill gets up to the podium again. So he's like going to stand there and he's like,
heard a confession from the defendant or have witnessed the defendant that led to the tip, right? And so I think it's important how that's presented, and hopefully you can work that out. And if you can't, we'll revisit how to do it.
That's what's going to happen. They're not going to be able to work it out. They're going to be revisiting this.
I've already spoken with the investigators to develop this.
we've already spoken with the investigators to develop this. Ready? And so he thinks that he's going to elicit this testimony from Officer Payne, like I said he would, and he can't. He can't, because Payne is already on the record in a previous hearing saying that, and this is a big thing that I did, going over hours of this before this motion limine, and I said, you guys, you don't understand. Ann Taylor did a tic-tac-toe 2 ways. They got him. Okay. And we were all so frustrated. What was Ann asking these questions for? And why isn't she, Ann Taylor got Payne to say everything that they needed, which was, what item led you to even start investigating Brian Culver? How did you get this tip? What, like, everything that transpired from it. And that it came from IGG, that it came from the DNA that they put into CODIS that was from the sheath. Okay.
This is to have probably Detective Payne, who was one of the leaders and lead investigators, to simply testify that they received a number of tips, that around December 19th, they received a tip. Following that tip, they took these steps. That's what we're contemplating at this point. Thanks, sir.
And so we have a pretrial in next month, and so hopefully you can come to an agreement on how this is going to be handled specifically by that time.
Oh, I love it. I love it.
To respond to.
They're so fucked.
No, nothing on that.
Nope, nothing.
Nope, nothing on that. Doesn't even have to say it there. That's not even the point to say it. They have to sit back and wait, and they need to wait and make sure that Hippler puts an order in that the IGG is out.
Nothing on that. Not here. It's not. Wait, keep it.
Okay, so next up is the alternate perpetrators. Okay.
We would also ask that the court set a reasonable deadline for the defendant to give the state and the court notice, make their offers of proof, so we don't have to encounter this in the midst of trial, that we can prepare adequately for the defendant. Yes, and the state's concern is about the defense focusing on specific individuals without count whichever we could.
And it's on pause.
Bill's back up.
Thank you, Your Honor. And this is actually a very convenient transition. We look at the history of this case and investigation. Of course, we, the investigators, and the state went probably some 6 weeks following the homicides, and during that time received thousands of tips and tried to substantiate or just discount whichever we could. Where we ended up is we were.
That's why I feel bad. I didn't realize that my mic was on. I'm just eating away for you guys.
Investigators were unable to substantiate any tips until they received the tip regarding Mr. Koberger itself. The state's concern in bringing this particular motion is that the defendant is going to try to offer alternative perpetrator evidence based on what we would call mere inferences that another person could have committed the crime. And the case law in Idaho says they clearly can't do that.
For purposes of your motion, are you talking about the defense's allegations of specific individuals? I mean, obviously, the defense claims the defendant didn't do this,
Yes.
which would suggest that there was an alternative perpetrator.
Yes. And the state's concern is about the defense focusing on specific individuals without making a threshold showing of connecting that individual to the homicides itself. And our concerns actually are reinforced by the defendant's response to our motion. When we look at pages 2 and 3, at the bottom of the page, the defendant says, this case is full of alternative perpetrators. There are many alternative perpetrators. That suggests to us that the defendant is going to shotgun any variety of people's names, and we think that they can't do that without making the threshold connection first. based on case law, based on rules of evidence 401, 402, and 403, State versus Meister is the most applicable case. We're seeking an order prohibiting the defendant from offering specific alternative perpetrator evidence without first having an offer of proof to the court that specifically connects this third party, this alternative perpetrator, to the crimes themselves. And then we've also asked the court set a reasonable deadline for the defendant to give the state and the court notice, make their offers of proof, so we don't have to encounter this in the midst of trial, that we can prepare adequately for it. So that's the nature of the state's motion, Your Honor. Thank you.
Okay, now here's the bombshells.
All right,
We
Matt.
do, as the state indicated, plan on providing offers of proof regarding alternate perpetrators. There's nothing about our approach that would be a shotgun approach, throw a bunch of spaghetti at the wall and see what falls. We understand that it requires the conditions of Meister and that we need to provide that information to you. We are still in the process of doing an investigation, as you know, with the amount of evidence in this case, and there's been a lot of briefing. There's going to be a motion argued about that. We are working as quickly as we can to put pieces together that make sense under the terms of Meister to present to you for that consideration with an offer of proof. So we understand the obligations. We won't be taking a shotgun approach. I would hope that the court would see that we are calculated and thoughtful in everything that we're doing in this case, and we wouldn't treat alternate perpetrator any other way.
Right there. Wow. Wow. Let me tell you what I think about that. First thing, Dylan's part of it. There's no doubt about it. That Dylan has to be part of the third party perpetrators, in my opinion. I have no problem putting out my theory on that, and I'll tell you why. After this hearing, we were all together for 9 hours and 30 minutes, by the way. And while I was resting over the weekend, there's two things that you're going to have to show to the jury to be clear and concise. And that is, the number one thing is that in order to believe the state, you have to believe Dylan and Bethany. Most importantly, Dylan. But because the moment that you don't believe them, then we have no idea what time the crimes happened. Right? So you're going to use, if there's available, the phone evidence of the surviving, or well, obviously the surviving roommates, but even the deceased victims here. Because normally what you do, and I thought that this was weird from the beginning, that normally in an investigation, you're going off of the deceased victims' cell phones. And in the probable cause affidavit, I noticed that they didn't go off of the deceased victims' phones at all, except for Xana with a 412 TikTok, which then we found out that that's not even accurate. It's 3:16 a.m. And that's significant, Harris. Significant. That's my new phrase for Nancy Grace. Significant, Harris. Who would be speeding away at 3:45? Significant. So I believe that Ann Taylor is going to move the time of the crime, and she's going to be moving it up. And then she's going to show that the staging part begins with these text messages, the deleting of the stuff, showing the consciousness of guilt, and connecting Dylan Morton to somebody else. And then that's where the partial alibi comes into play. Is that Brian Colbert, that everyone believes that the partial alibi is about that just because he's cars facing this way and he's going that way for 7 minutes, right? Well, yeah, sure, that's part of it. But the other part is that if Brian Colbert is over here during that time, he can't be two places at once because we're moving up the time of the crime. And then we're bringing in the whole staging effect of it after the fact, and then the covering up of it. And then now you're going to be talking to the jury about from the time that Dylan Mortensen supposedly saw this masked man until noon. These are all of the things that happened. Okay. And not one of those things were that she ran out scared, went and got help, called 911, nothing. These are all the things that she did do, though. And then she started deleting things, right? I think that they're going to have a witness or two that are going to show a pattern of life history of Dylan Mortensen through her cell phone, as well as Bethany. Does Bethany normally call her dad or her mom at 7 o'clock in the morning? And there could be one other possibility, one other thing, which is if there's evidence that Dylan and or Bethany were not home at 4 o'clock in the morning, 4:30 in the morning. And if they're able to prove that, then they are there to then none of this stuff that they claim could have been anything because they're not there type of thing. But either way, after much consideration, Ann Taylor, in my opinion, is going to move the time of the crime, and she has no choice. If she's already put out all of this stuff about Dylan Mortensen's text messages being deleted, her putting in a phone contact at 3:51, the saying the whole 3:16 TikTok versus the 4:12. I mean, it's a big damn difference. But that's where you're going to get your partial alibi, and saying that whatever you're seeing here, if the investigators would have done their job, they would have realized that Dylan wasn't being truthful. And if Dylan's not being truthful to them, okay, it would be a mere fact of like saying like, I don't remember something, versus at 3:51, you don't remember that you were saving a contact, but that you just woke up at 4, though, up out of the blue. And it's going to be for whatever reason, the police, and this is what doesn't make sense to me, is that you're believing these girls without looking at their cell phones and having actually somebody look at the cell phone that did the Cellbrite dump and to see that this stuff was deleted. If that didn't come out in an interview, then why wouldn't you be asking them that? And that's why I think then that ties into the sororities / fraternities. Because, but can you say all of those things to a jury? What would be the motive for the police officers not, hey, you see that she's lying. Why wouldn't you go and ask her about it? You know, if you truly looked at the Cellbrite, right? What Josiah Roloff found is the same thing that these investigators would have found. It's right there. It's Dylan deleted this stuff. Dylan, oh my God, there's a contact here. Everything that Josiah Roloff found, these investigators should have found. And so that's what would bring you back to Dylan to be asking, these questions, which is, okay, what number did you save? Who is this person? Okay, you really weren't sleeping, but you told us that you were. What truly happened that night? If there's no line of questioning of that type of questioning to Dylan based off of having the phone and you dumping it and you would have had that information, then Ann Taylor is just going to simply, in my opinion, just say they failed at doing their job. And then these girls talked about this time frame, okay? And it was they didn't want to see other friends get in trouble. But then we hear this, and we got some names we're going to be giving out. So it's not just going to be like Dylan. It's going to be Dylan, lookout, scared girl, covering for other people, and then boom, who are the two people? And so I think Ann Taylor's going to say that it's unreliable to even say that the crime even happened during the time frame that they're saying. based off of the lies. Like now we're supposed to believe them that this truly happened during this time like this. No. So then that car doesn't have anything to do with anything. Regardless of what car it is, it has nothing to do with the crime. And then here everyone's saying, well, it doesn't change the fact that Brian Culber's touch DNA period is on a sheath, right? Absolutely. It doesn't change that. But that's not on the defense to explain that. It's on the state to explain it. And that's exactly, I believe, how the defense should go about it, and to bring people in there to show how an item like that could cause, like, you're getting hung up on that. But we're not going to talk about the blood. We're not going to talk about the two different male blood that's in that house, and that was never tested, versus here's the sheet. That's all we're going to upload into CODIS is that profile, but we're not going to upload the blood. And then we have the lead investigator thinking that you can't upload multiple profiles into CODIS from the crime scene. That's absurd. And for him to even think that, Idaho State Police knows better. The feds know better. So, they really need to hit home here, and I believe that they will, based on how they're methodically doing everything, is that they keep talking about, the defense keeps talking about it. This burden is not going to be shifted to us. The burden, okay, it needs to stay with the state to prove their case, right? Well, what if I told you guys, I'm going to throw this wild, and you guys are going to be like, whoa, you really think that? What if I told you there's a decent chance right now, there's a 50-50 chance, which is way more than anybody would ever give, because it rarely happens. But ready? That what if Brian Culber goes for a bench trial? What if Brian Culber says that he wants this to all take place in front of the jury, or in front of just Hippler and not a jury? You need to seriously think about what I just said.
I don't believe the state has anything further on that point.
I think the parties are both correct in that State v. Meister is controlling here, where the court has spelled out that if the defense intends to present specific alternate perpetrator evidence, they have to make a factual showing that would, in fact, connect such a person, rather than just throwing names out.
They're testing that blood.
Without evidence to support that. I don't want to do that at trial.
You do that all the way up to the end before
I
you.
think that's not enough time for the state then to investigate that. And I don't think it's enough time for the court to respond to that. And I think we'll waste a lot of time where we are not having trial as a result. And so what I would like to do is to look at a date shortly around the time of the pretrial to hear those proffers. Reach out with your calendars and set a date to take them. Did they believe the evidence that there was more than one perpetrator from presenting that sort of generic, unknown unsub, to use the part of the craft.
I can promise you, we've already heard a little bit, and it's two people, two knives. I'm going to tell you a little bit later on why I'm saying that it's 50-50 in my opinion. It's 50-50 in my opinion, because they're going to see what stays in and what stays out. At the end of the day, the evidence is the evidence, okay? If you guys want to roll with juries, have you guys seen what has come back on juries? Richard Allen's case, okay? Karen Reed's case. These are clear-cut, reasonable doubt cases that no doubt about it, don't know if they're guilty, don't know if they're innocent. Let's just say, okay, one of them comes back guilty, the other one comes back a mistrial. Reasonable doubt is so lost on the American people right now when it comes to the criminal justice system.
Involved. This relates more to allegations of somebody more specific, identifiable. All right. Let's talk about DNA, which is the inconclusive data, the statistical analysis, and the reference to touch and contact DNA. Let's take up the first two, and then we'll take up. I think the first two relate to kind of the same thing to a degree in terms of the science of statistics and probabilities and all that. There are really three issues, as I understand it. One relates to how to convey
under the fingernails. And so that's where that is coming from with the inconclusive data. On the issue of the statistical analysis, that we agree. I mean, we're not going to ask that question. The only kind of remaining issue we have is I think their motion specifically asked for an order excluding that question or other questions like it. I'm not a big fan of that language because it's just kind of vague and we're not entirely sure what that means, but we'll stay completely away from the population of the world or a country or a city or anything about population. That's all. Thank you.
The way in this motion supports that state test.
A little bit about the state's position.
Please do.
The state has no intention of suggesting to the jury that, oh, maybe this is Mr. Koberger's DNA. We just don't know. That is not what the state is trying to accomplish. What happened is the Idaho State Police Lab tested this DNA and they came up with their likelihood ratio. And that number fell within a buffer zone. And under their policy, that buffer zone, generally speaking, with a likelihood ratio,
A buffer zone.
your policy is if it falls within that range, 0.01 to 100, we report it as inconclusive. Not just meaning you can't.
I believe that they used true allele and something else, but I think it's going to be interesting if they can just give us. I would just love to see that if they use true allele or not, because true allele can separate mixtures. So I just want to know if true allele was used in this case. 235. Let me see if I don't know if it was like a slip when they said if she like misspoke on the true allele part.
He reanalyzed the data visually, but he also used another statistical tool. And he stated in his conclusionary paragraphs, and it's a very long report, that first he looked at the data using the lab's protocols and doing some validation himself, essentially looking at their validation studies. And he found that just visual examination of the data excluded Mr. Koberger. He went a step further and he said, I'm going to use this new third tool called LR Mix Studio to generate the same statistic or similar statistic that the lab did, the state lab did, as well as true allele cybergenetics did in their analysis.
Cybergenetics. So she says true allele, but then she's like cybergenetics. Okay. Just so you guys know, none of those fucking things were used in Delphi. And I was just like, what the fuck, Indiana?
Analysis. And he came up with a strongly exclusionary statistic.
So
So we have now before the court, as he describes it in his disclosure, a statistic from the state lab, which means that it's 25 times less likely if the DNA originated. I always have a hard time with these numbers because you have to be extremely careful how you say this because it can flip the meaning. So let me just double check. His statistic, I'm sorry, I'll start with his. It's 5,000 to 100,000.
One suggests exclusion, greater than one suggests inclusion. But they had done their own internal validation studies and it found that they were getting some false positives and negatives when you're close to that one. And the range that they came up with was 0.01 up to 100. And so their policy is if it falls within that range, 0.01 to 100, we report it as inconclusive. Not just meaning you can't, uninformative. You cannot draw one way or the other, whether it's exclusion or inclusion. And so that's what we had from the Idaho State Police when we went to the grand jury. We thought that it was important. What we were trying to portray to the grand jury was that there was the only DNA that connected Mr. Koberger to the crime scene was on the knife sheath, but the analyst wasn't willing to just make that general statement because there was this issue.
Okay, right there. So the only DNA that connected Mr. Koberger was to the knife sheath. Okay, how he just said that. My argument is moving forward with this jury. Okay, how are you able to tie Mr. Koberger to the DNA from the knife sheath versus just any DNA found at the crime scene? Now, I'm going to repeat this. Ready? Ready for this? I think I solved the big mystery, okay, as to why they never put the blood into CODIS. You guys are going to be like, whoa, Lana, this is fucking deep. Okay. If you can't talk about the IgG, right? So how do you say that you know that Brian Koberger's DNA was at the crime scene if Brian Koberger's profile isn't in CODIS? Why would you ever have a reason to believe that if you went and got the trash from a guy in Pennsylvania that went to school at WSU that has no ties to these girls, how and why would you ever go get the trash to then test it? And oh my God, this is a statistical match to the this is the dad of the sheath lever, you know? So how is the state going to tie Brian Koberger to the DNA on the sheath in this case? So the defense says, okay, so you got the name Brian Koberger. Well, you had DNA at the crime scene, right? Did you, from the lab, right? Okay, so you have DNA at the crime scene. Did you match any of the DNA at the crime scene to Mr. Koberger? Yeah. What DNA? Where was this DNA at? It was on the knife sheath. Knife sheath. So were you able to extract DNA from the knife sheath? Yeah. Did you upload it to CODIS? Yeah. Did you get a hit? No. So then how did you match Brian Koberger's DNA? Was his DNA in CODIS? No. So how did you IgG? How are you able to say it? You aren't. So then you have to back all the way up, then back, so erase everything I just said. Okay. You did, remember I said this in the beginning. How did you, if you're going to tell the jury that Brian Koberger's DNA was matched, remember after he was arrested, his DNA was taken because we swabbed him and it matched. Wait, did you just say after his arrest? Oh, wow. So you arrest Brian Koberger before you ever got his DNA? Why did you arrest Brian Koberger? This is going to be insanity. This is going to be insanity. This is going to be insane. If they say that they only uploaded one profile into CODIS, right? Then they testify that they only uploaded one profile into CODIS and the profile was from the sheath. Then the jury knows that no other DNA from the crime scene was uploaded to CODIS. So I thought about this and I'm like, there is no fucking way that they would know and be that smart, unless this wasn't a complete fucking frame job, that you would not upload the blood or anything else that you obtained into CODIS so that you could at trial say that the only thing that we uploaded was the sheath, the DNA that we got off the sheath into CODIS. But it didn't register a hit. And then you're really going to have people testify and say, I didn't know that we could upload other things, so we didn't. But 120 people were working on this case, and just because your second year detective doesn't know that, or deputy, or whoever, like, you know, your patrolman doesn't know that, other people wouldn't be like, wouldn't the lab have something to say about that? Wouldn't the lab have something to say about, like, here's all the samples that we were able to pull from them? Do you have any stuff for us to compare it to so we can eliminate some of these? Right? And then when they use all, you know, the roommates and then like really good friends of the roommates and then parents and stuff like that, people that, you know, it wouldn't be foreign because there's rules with CODIS, right? Okay. That's according to Payne. I'm trying to picture myself being a juror listening to this, listening to they just arrested some random guy. And then after they arrested him, they were able to get his DNA like that. And then they compared it to it was a hit off of one of the items that they had at the crime scene. Interesting. They compared it to some random, fuck the random man. They compared it to a family in Pennsylvania. They just took the trash from, well, because then this is what's going to be said. Okay, so you guys think that this is a Honda Elantra. Great. Okay. So did you guys start driving around and picking up DNA from people that had a white Honda Elantra in the area? Like if they like went to school there, if they went to WSU. No, we didn't do that. Okay. You didn't go around picking up people's DNA or their trash and just like go through it and to test objects to see if you could get a hit? No, we didn't do that. Well, we did that with one person. Brian Kober's family. So you do that in December of 20 whatever day. How did you get to Brian again? Who's Brian Culver? Do they go to school together? How does his name come up? His name really doesn't come. His name doesn't come up. Well, there were these two officers that were on WSU's campus, and they came across, a bunch of white Honda Elantras that, and one of the names came across. I thought we had seen his name before in the, what? Detective Mowry. Let's just make sure. Let's get this really specific here. Detective Mowry, did you look through the tips? Who was going through the tips? Who was going through the tip line? Oh, no, that wasn't my job. It was somebody else. All these people get asked. Okay. And what would you do with the tips when you would go through them? Hey, you were just assigning them. Hey, you look into this. This is what came in. So who's assigning the tips? Okay. And did the name Brian Culver come through on the, the tip line? No. Did Brian Culver's name come through? Did he date any of the victims? No. Was Brian Culver's name in any of the victims or the surviving roommates' cell phone numbers? Or in their cell phones? No. We found out that Brian Culver had a white Honda Elantra. How? Oh, wait. Let me back that up. When did you find that out? We found that out December, I don't know, 19th or 20th. We found out that Brian Culver had owned a white Honda Elantra. So when you say like we found that out, can you explain that process? We were just doing research. What? Okay. Like, I'm trying to figure it out. I'm trying to figure out how they could do this legally. Brian Culver. How did we get to Brian Culver if we can't say that the FBI took the sheath, or I'm sorry, the lab put CODIS in, didn't get a hit, but then we decided only off of that one piece to do IGG because we can't talk about any of that. And since the state in the defense did not come to an agreement on how to be able to introduce this generic tip, well, can I just say that we got his name on December 19th? No, how did you get his name? Was it a confidential informant? No. Was it one of the victims? One of the surviving roommates? No. Was it from their phones? No. You guys, this isn't going to work. This is not going to work because it all is going to boil back down to if you were trying to link him to the crime scene because there's this DNA, then why didn't you go get his DNA? Why did you wait to get his DNA until after his arrest? Generic tip is a lie, though. Exactly. Officer Payne, didn't you testify in another proceeding or in an earlier proceeding with this case? Didn't you testify? Yes. And isn't it true that you testified that the way that you explained it here today is not how you explained it then on how you got to Brian Koberger? That's correct. Like, Hitler doesn't understand. Hitler doesn't understand that they didn't have probable cause to arrest him, and this is what's leading to all of this problem. Judge sealed the Munster case in 2023, 9 years after case was done. Why did that happen? Another case that Ann was in got sealed too that I was looking into. So the defense is going to ask, and you'd be a fool if you didn't, and you'd be a fool if you didn't argue this way, which is, Your Honor, if the IGG is out, it's everything that came from it. It's all of it, which is wiping out the sheath. And then Hitler's going to say, like, I don't see your logic and blah, blah. Well, let me explain to you then, Hitler. If we let them have any other way to say that they got to Brian Kober other than the IGG, it's a lie, because we all know the real reason. And this isn't the same as a 403B issue of a prior bad act. We're not trying to keep out a prior bad act of Brian Koberger's. Okay. We are not in agreement that just because they lied on how they made probable cause and you allowed it, that now here we get to come to trial and they now need a way to bring up that they got to Brian Kober by some generic tip on December 19th. And that's a lie to the jury. We've already had testimony as to how they got to Brian Kober. It's one thing to suppress something, okay? It is another thing to add evidence that's not there. And can Judge Hitler say, well, no, I'm going to allow them to lie? Bigger issue is, does Hitler really not realize they didn't have probable cause, or he knows and just letting the case and BS? Basically, it's like okay, there's going to become a time that you're eventually going to get caught with something that you did. It's just a matter of time until you get caught. Okay. That's what this is. This is the eventual, like, when is, hey, I'm pregnant. It's going to come a time that people are going to notice that I'm pregnant, right? Notice. Okay, there's going to come a time. But then there's going to become it's inevitable. The baby's here. Okay? That's what this is to me. Okay? The state is pregnant. Okay? With the IGG baby. And, okay, you want to act like you're not pregnant and you want to hide it for the first month, for the second month, for the third. Okay, you still want to act like you're not showing. Okay. All right. Then they even tried to abort the baby. The state hid it, right? The state hid that they ever even used IGG, right? So we're hiding it. Then they tried to fucking abort the damn baby. Now here it is. When are we going to be? Boom, the baby's born. Oh, fuck, you were pregnant the whole time. The time is now. And the IGG baby is going to be born. This is an IGG baby that they've been lying and hiding and covering up for all this time. And here, Hitler literally was like, you can tell them how you know, the car, and it's like, this is what I find is fucking crazy to me. Ready? Hitler, why wasn't your answer that they would just do what they did for probable cause? Why wouldn't his answer be just like how they didn't use IGG for probable cause, they're not going to use it here. They don't have to. That was just overemphasized. Like that was just the IGG that just made it more, boom. Right? So that's the argument. That's the argument that Ann Taylor is waiting to make through Bicca Barlow, is that, Your Honor, we had a Franks hearing. We brought all of us to your attention. You wrote in your order that no, they clearly got to Brian Kober with the WSU shit. It was inevitable. That it was inevitable, and that they clearly got to Brian Kober via the WSU car shit. Okay? And Taylor's like, the fuck are you talking about? They didn't have WSU in any of those fucking videos until December 20th, which is after the 19th. Hold on 1 second. Okay. I'm just waiting for this moment. In this moment. Hold on 1 second. All right. I'm sharing you guys a screen. This is Hitler's IGG baby. Okay. Order. 17 order. Okay. Order on defendant's motion to suppress warrants. Order on defendant's motion to suppress genetic information. There we go. Okay. I'm gonna tell you guys to zoom in here and look at this for a second. Now, Judge Hitler's order. This is, you're not going back on this. C, defendant has not met his Franks burden on issue misleading timeline. Okay. This misleading timeline. This is everything. And in issue 5, defendant claims that law enforcement created a false narrative of their investigative timeline in Exhibit A so as to make it appear that the defendant was identified through their investigative efforts and not, in fact, through IGG. Okay. Do we see this? This was up for a Franks. You guys see that right there? Defendant has not met his Franks burden on issue 5, misleading timeline. In other words, he argues that law enforcement, having already identified defendant through IgG, tailored their Exhibit A to support probable cause for an already identified suspect, not an unknown suspect. Defendant provides 2 examples of what he contends are misleading timelines about his identification, but these examples fall far short of the Franks standard. First, the defendant notes that in Payne's Exhibit A, defendant Payne states on that November 29th, 2022, officers from Washington State University queried white Hyundai Elantras registered at the school and pulled up a 2015 white Elantra with Pennsylvania plates that was registered to defendant. Exhibit D3B at Bates 5166 and 67. That same day, Detective Payne states that another WSU officer was patrolling the area by defendant's apartment and located a 2015 white Elantra with Washington plates. He ran the plate and it returned to defendant. Defendant points out that Detective Payne was not even aware of the WSU officer's findings in this regard until December 20th, 2022, after defendant was already identified by IgG. However, he contends Payne's Exhibit A makes it appear that defendant was identified, he says, in part through the WSU queries. There's nothing about in part. There is absolutely nothing in part about it. That's exactly what the world thought. The world, not just magistrate Marshall, the entire world. That's exactly what mainstream media thought. It's exactly what everybody thought. And here's Bill, spread that shit far and wide. He adds that in part, in my opinion. Then, through the WSU, Second, defendant takes issue, and she uses the word, takes issue with Detective Payne's focus on suspect vehicle 1's lack of front license plate. In Payne Exhibit A, he discussed his review of surveillance footage, noting a review of camera footage indicated that a white sedan here after suspect vehicle 1 was observed traveling westbound on Steiner Avenue at Idaho State Highway 95 in Moscow at approximately 3:28 a.m. On this video, it appeared suspect vehicle 1 was not displaying a front license plate. They take issue with it because nobody fucking said that. We have now Immel's report. Detective Payne later points out that the defendant registered his 2015 white Elantra with Washington State on November 18, 2022. He noted that previously the vehicle was registered in Pennsylvania, which, unlike Idaho and Washington, does not require front plate. Defendant contends that although Exhibit A makes it appear that law enforcement was focused on the lack of a front license plate early on, it was not until after he identified through IgG that it became an object of inquiry. Again, not all of this right here is just blah, 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 because I told you guys there's no way this is Ann Taylor's argument. But Hippler is just writing this in his order. Like, that's why I was like, hey, if you want to release everything, release Ann Taylor's actual brief on this shit. Now, this is Hippler. This is what Hippler says. In neither example has defendant established Detective Payne's investigation timeline to be misleading or false, much less intentionally or recklessly so. Now, if you don't think that Ann Taylor is going to use this fucking ruling to say, Your Honor, we don't need you to give, or they don't, to use any generic of anything, right? Why are they asking you that they need some way to show how this investigation progressed if the affidavit is in fact true? You understand? And Hippler had an aha moment But Ann Taylor wouldn't go there. Okay. And I'm going to show you this point to end out today because I want to keep it right around 2.5 hours. The part that I'm going to jump to is when Hippler has an aha moment when he's wanting to scold Ann Taylor for why the fuck aren't you having, these are some serious allegations of people's jobs will be disbarred, all this shit, right? So in either example, the defendant, there can be no question that the defendant was identified in part through the WSU officer's queries and through the suspect's lack of vehicle as observed in surveillance videos from the night of the murders. Look at this, you guys. This is absurd. The fact that law enforcement had additional DNA evidence tying defendant to the crime does not render it improper for law enforcement to rely on independent evidence accomplishing the same. Independent evidence accomplishing the same. His own order. This is when the baby's born, okay? The baby's born now. Judge Hippler, you make it perfectly clear that there is no question, there can be no question that the defendant was identified in part through the WSU officer's queries and through the suspect's vehicle lack of a front license plate, both of which are false, as observed in surveillance videos from the night of the murders. The fact that law enforcement had additional DNA evidence tying him, that does not render it improper for law enforcement to rely on independent evidence accomplishing the same. Keywords, accomplishing the same. And that's what Ann Taylor is going to show him, is that you said that law enforcement can accomplish the same without the IGG. It would arguably be irresponsible for law enforcement to rely solely on DNA evidence without making an effort to corroborate it, particularly given the novelty of IGG. Yeah, but you're missing a huge big point, you fuck. And that huge big point is that they didn't even mention the IGG in the probable cause affidavit. And that's where it would become irresponsible for them not to double check their work, but they don't ever list it. Defendant has not established there is anything wrong with this approach. What approach is that? What approach is that? Observing the requirement under Franks that search warrant affidavits to be truthful and complete does not require that every fact recited therein be correct or that every detail of investigation be provided. Indeed, what is important to probable cause is the totality of the evidence. What's all gathered and examined in light of what the collection of evidence shows. Not looking at it in isolation as each piece of evidence was separately gathered. Moreover, had law enforcement indicated in Exhibit A that the WSU query and lack of a front license plates only came across its radar after defendant had been identified through IGG, defendant has not explained how this would have eroded probable cause. Wait, it gets better. It gets better. Wait a second. Moreover, had law enforcement indicated in Exhibit A, like the probable cause affidavit, that the WSU query and lack of a front license plate only came across its radar after defendant had been identified through IGG, defendant has not explained how this would have eroded probable cause. Exactly, Hippler. it would mean that they would have to mention IGG on the motherfucking probable cause affidavit. And then it wouldn't matter because they are giving a clear path on how they got to Brian Koberger, right? But they didn't mention IGG. In fact, they acted like IGG was never birthed, that we never conceived IGG, that IGG was never conceived. Okay? And that's a goddamn lie because without IGG, there is none of this. And when that comes out as being fact is by the mouths of these prosecutors to say that we got to Brian Koberger because of IGG. This is how this happened. And now we need a generic tip to be able to say, so we can explain to the jury how this naturally progressed. And the audacity that the state truly is asking for this after they told fucking Hitler that how we got to Brian Koberger is legit. Like the probable cause affidavit is how we got to him. And Ann Taylor's just like, what the fuck are you talking about? No, they didn't. No, they didn't. So now they admit that they didn't. And so wouldn't this be like, hello? And it is. And so bring in now the cameras. So that's his answer is that he says that there can be no question that the defendant was identified in part through the WSU officer's queries and through the suspect vehicle's lack of front license plate. The fact that law enforcement had additional DNA evidence tying the defendant to the crime does not render it improper for law enforcement to rely on independent evidence accomplishing the same. And that is what's going to happen. The agreement is going to be, go ahead, offer up your probable cause affidavit. We're going to stomp it. Because you're not going to be able to use IGG in any capacity. Because you didn't, because you went and got Brian Koberger's parents' trash. For what purpose? When? You had nothing to compare it to, right? Well, yeah, we were going to compare it to the what? Well, to the DNA that we uploaded in CODIS from the sheath. Why? Why wouldn't you compare it to the blood? They're not going to be able to do any of this. I've never seen a sheath do so much damage. So then here's Hitler. And then Ann Taylor doesn't fall into the trap. So then at the 5-minute mark, and let's see. So we're going to come back and do the second part tomorrow. Don't worry. So at the 5, but I'm going to end with a bomb for you guys. At the 5:39.
An order met when speedy trial was waived and the trial was reset and all of the deadlines were extended. That was the thing that happened there. So it wasn't repeated times that we had an opportunity to say more. But I will say this. This has been brought up repeatedly by Mr. Thompson. His pleadings with the court, his briefing, have a lot of reference to Mr. Koberger having the ability to testify. In the few minutes he spoke just now, and I think that if that
if not in your testimony, your presentation is that this is what was going on, you have to have somebody that's going to put that into evidence. You can't testify to that.
I'm certainly not planning to testify to that. I'm responding to requests for alibi. And a lot of times in cases, there is not that about that if he's allowed to.
Work.
Okay, here we go.
He's going to testify the defendant was at a certain place at a certain time, which is.
Here we go. We'll talk about that on the break. Ashley Jennings.
All right, let's talk about the AT&T stuff.
Oh gosh. AT&T stuff. Oh gosh, Ashley Jennings, here we go. Oh no, I feel bad for her.
Thank you, Judge.
Give her grace, give her grace,
This
guys,
should
give her
be
grace.
fairly simple. The state seeking an order prohibiting the defense from continuing to allege that the state received timing advance records from AT&T for Mr. Koberger's.
When you say continuing to allege, I'm assuming you mean in front of a jury.
Yes, what we don't want, throughout the entirety of this case, they've alleged that. We're seeking to prohibit them from making that same allegation in front of a jury because it's false. Timing advance records, really timing is what's at issue. And in 2022, the days that we're concerned about are 7 days. The event that we wanted records for was obviously November 13th. So in 2022, we had 7 days from November 13th to get AT&T timing advance records for anyone's phone. We did do search warrants for.
Okay, right there. Right there. The same person that has no idea about timing advance records prior to this day, the same person, Ashley Jennings, who says that timing advance, what the fuck is timing advance records? You know what I mean? She then gets up to the podium and is like, we only had a 7-day window to get timing advance records from November 13th. Okay. We only had. How do you know that, Ashley? What are you talking about? Now all of a sudden you know about timing advance records?
Other people's phones. We did a tower dump and we did a search warrant for 3 individuals. Those were all done on November 16th within that 7-day period. So the state did receive some timing advance records.
So their early lead in this case, which she kind of just gives a clue there, so write this down, that on November 16th, when they did this for the 2 phones plus the additional third phone, the third phone was the person they were interested in the beginning. They were interested in this person on November 16th, and they went for their AT&T timing advance records. Okay.
However, by the time that Mr. Koberger was identified in December 19th, and by the time we applied for a search warrant for his AT&T records, we were outside of that 7-day window. So there were no timing advance records to be received, and we did not receive any. The state has submitted an affidavit from Stephen Gordon, the AT&T Director of Compliance, essentially stating that we sought timing advance records, but they were not included because more than 7 days elapsed since November 13th, 2022, and the date of the search warrant, December 23rd, 2022. And the state just submits these affidavits should be dispositive of this issue.
The defense filed a document yesterday. And I don't have all the attachments, but it talks about a timing advance that was produced by AT&T in last April, I think.
Yes, so for that, it's still in reference to these search warrants that were initially asked for in November 16th of 2022. We did a part 1, and then later we did a part 2. But because we put in that request within the first 3 days, obviously a preservation request was also put in. So those.
Okay, so this is really important to understand. So a preservation request was put in. So understand this. Back in November, she's not even saying the right days. Back in November, on November 16th, okay, they put, what you can do is you can put a preservation order in, all right, and it would preserve the information that you could get right then and there. Let's just preserve it in case we need it down the road, okay? And so there was evidence that showed on April whatever of 2023 that they received timing advance records again. And what Ashley Jennings is saying is that, yeah, because we put in back then, we preserved records back then. Okay. That's her argument, is to say that, and these were just, so think about this now. This has nothing to do with Cy's affidavit yet, because this was just a day ago. Cy's was in way before that. All right. So there was something that was submitted, unless he's just throwing out dates right before this.
Those records were obtained. So again, we're talking.
You're indicating that there were records obtained as part of your prior notification of need for AT&T to preserve those records.
I have nothing further. Thank you.
Wait, a preservation order for what? Oh gosh, here we go. And okay, so right there, I noticed it. And I said, wait, a preservation order for what? Like, she was very vague here. Was it a preservation order for all 3,800 accounts? Or was it a preservation order for just those 3? Because let's be honest, it'd be a preservation order for all those 3,800 accounts, just because we don't have time to go through all that shit, right? We have to, we don't know, one of these people is the killer. You know what I mean? We need this stuff. Like, that's what they're probably thinking. Taylor. So let's see how Ann handles this.
Your Honor, we're requesting the court deny the state's motion and allow us to cross-examine their expert, Nicholas Balance, with regard to timing advance
What
records.
evidence do you have?
Okay, perfect. This is about the motion. They put in a motion in limine. This is really, really important, guys. Ann Taylor was so tested here, and I'm breaking it all down. The motion in limine was put in by the state to say that you are not allowed to talk about timing advanced records. There will be no cross-examining anybody and asking them about timing advanced records, period. That's what this motion is for. Okay. Ann Taylor says, we are asking the court to not allow that, and so that we can cross-examine Nicholas Balance and ask him about timing advanced. Because it is not just in reference to, there's reasons why, okay? There's reasons why. And it has to do with how you're mapping everything. So there's multiple reasons why, and it's just a simple thing is we're asking you to not grant them this because we want to be able to ask Nicholas Balance through cross-examination questions about timing advance, period. That's it. That's it. Now, let's see where this goes.
The timing advance records existed that the state could have acquired for Mr. Koberger.
Well, Your Honor, specific.
I've read your affidavit of Mr. Ray, and he seems to entirely ignore the 7-day issue and doesn't address it.
Your Honor, his affidavit, I think, starts before to explain to the court some of the history about where the timing advance records come from. When Mr. Koberger was identified, I'm going to jump ahead and tell you why I think I should get to ask Nick Balance about these records. When Mr. Koberger came to the attention of the state and they began doing search warrants for Mr. Koberger's records on December 23rd, there were 2 separate search warrants for Mr. Koberger's AT&T records, and they requested timing advance records. And one of the pages that we gave you was the carrier request that said, give us 7 days worth of timing advance records. There were 7 days back, at least 7 days back at that time. Those have never been produced to us. What I've learned in working with Mr. Ray is that obtaining timing advance records now goes through a different process than it went before. FBI agents had a means to get these timing advance records before they were generally available to all of law enforcement. Generally available now comes through the GLDC program, and that happened in 2023.
But he's not indicated he has any evidence that, at least for this time of the murder, that those would still be in existence.
We've never heard from Nick Balance, who is FBI and who has the back door.
From AT&T.
You've heard from AT&T that GLDC did not produce these records in 2022.
Right there. You've heard that they didn't produce these records back then. That specific avenue did not produce them. That specific avenue.
You've absolutely heard that from AT&T. What you haven't heard is the other way
That's the other way. I haven't heard that either. I've heard
What you've heard is that way. What you haven't heard is this other way. Ann Taylor is not going to testify for Cyray. And why? So, does everybody understand that? Ann Taylor is not testifying for Cyray.
heard a general description, and I've heard in the affidavit that he received some once, and they said, "Oh no, don't use those." I don't know if those were acquired within the 7 days.
This is why she wanted Cyray to testify.
And that's a glaring, particularly given the inflammatory language in that accusation.
He just summarized an affidavit that is fucking loaded with shit. Okay, loaded with shit, and just said, what exactly? If you want to fucking know something that somebody put in an affidavit, then you can, he's here, he's available, call him to the stand. Isn't that what you would do? If I want to know something about something, I'm going, Ann Taylor didn't submit the affidavit. She submitted it on the, I mean, she had to enter it into the fucking docket, sure, but she didn't write that affidavit.
In that affidavit, it's a glaring omission.
It's not a glaring omission of anything. It's not a glaring omission because the way that you can get them the other way has nothing to do with how many days and all that bullshit. Okay. There's other ways to get it. And
Your Honor,
period.
we don't even have the 7 days worth, which is what the carrier request says. That
For the 7 days that he's back home.
maybe.
Right there. Look at him. What, the 7 days that he's back home? Wait a second. That's not. Her argument is we don't even have those. And then the question should be like, Miss Jennings, where are they? Did you guys ever obtain those? Okay. Like he says, what, the 7 days he's at home? Well, your job is what your job. So are you trying to say that that's not relevant? Because if those aren't motherfucking relevant, then how the fuck is a goddamn getting pulled over and talking to a police officer on an August 21st body cam motherfucking relevant to this case?
I'll ask the state about those, if they receive those. I'm not sure their search warrant covered that time frame, but
He doesn't want to get the source.
Your Honor, I
Ooh.
would say that it did. And I would say
Wait.
the first search warrant.
Why wouldn't you just ask right now? Miss Jennings, did you receive those? I'll ask the state about, when are you going to ask the state about those?
Was just a 48-hour period. It asked for timing advance records. But then the second warrant,
you would
which
agree there's no evidence that AT&T provided those or that those were still available by the time that Mr. Kohlberger was identified.
Your Honor,
An officer of the court.
as an officer of the court, I would like to ask Nick Balance that. And here's why. Here's why. The things that I've learned is that the 7 days is on paper. Sometimes they go back further than other days.
What's the evidence of that, counsel?
The evidence has been in the practice that I've learned from people that I've
You're
worked
giving
with.
me the testimony now,
I'm not giving you testimony. I'm answering the court's question.
but you've made some serious accusations against the state of hiding evidence, and yet you've provided no factual basis, zero, that evidence existed. For
And the third,
AT&T provided.
but then the second warrant,
You would
which
agree there's no evidence that AT&T provided those or that those were still available by the time that Mr. Kohlberger was identified.
First of all, we are here requesting that they are not allowed. Well, how come you allow them to not talk about timing advance? How are you trying to say that we can't talk about timing advance? Why would that even be? Who cares if you're the state? Who cares? I can't ask you about a search warrant that you applied for where it said timing advance on him. And so you're saying that you didn't get those back? It's on the search warrant.
all right,
An officer of the court.
as an officer of the court,
Wait, as an officer of the court, then you're asking her to do what? He just said, as an officer of the court, what? And then he says, wait, are you going to testify? Motherfucker, you just said, as an officer of the court.
That AT&T provided those or that those were still available by the time that Mr. Kohlberger was identified.
Your Honor,
An officer of the court.
as an officer of the court, I would like to ask Nick Balance that. And here's why. Here's why. The things that I've learned is that the 7 days is on paper. Sometimes they go back further than other days.
What's the evidence of that, counsel?
The evidence has been in the practice that I've learned from
You're,
people that
you're,
I've
you're
worked
giving
with.
me the testimony now?
I'm not giving you testimony.
How is she giving you test? You just asked her. You just asked her a question. Are you giving me testimony now? The fuck? You just asked me a question.
I'm answering the court's question.
But you've made some serious accusations against the state of hiding evidence, and yet you've provided no factual basis, zero, that evidence existed.
And that's not true. And Anne, I don't know if Anne did not read the fucking affidavit, good or the inside Ray's affidavit. It does give the evidence. So I don't know if Ann Taylor did not read it good enough, right? Or if she was told, whatever you do not get into this back and forth with this man. This is not the time. If he's not going to call me in on this, do not argue about anything about this, because we are not arguing our case. Okay? We are not arguing our case. We're not showing our hand. This is a simple motion in limine to make sure that an order does not happen where we cannot talk about timing advance. That's what this is about. Nothing more. Because And I believe it's this route. Because she kept going back to it. Your Honor, I'm asking to be able to cross-examine Nicholas Balance.
For them to be able to obtain it in December.
Your Honor, in April of, or I'm sorry, it was probably by the July date that I got it, of 2024, I got records from 2022. In some other time in 2024, I think it was May, I got 3,800 people's timing advance
Because they were
records.
asked within 7 days of the date that they sought it.
Wrong. Abso-fucking-lutely wrong right there. That's not true. How would you get 3,800 people's timing advance records, okay? 3,800 people's timing advance records through GLDC, if GLDC was not doing timing advance, meaning that you're going through local law enforcement, right? If GLDC does not do timing advance until 2023 in June, then how the fuck did you get GLDC timing advance records from tower dumps of AT&T on November 16th? Where'd you get that from? November 16th of 2022. GLDC was not doing timing advanced. Like that source, that avenue. Okay? So again, I don't know if Ann Taylor doesn't understand it well enough. I don't know if, what's GLDC? That's the Global Legal Demand Center for AT&T. That is if you are local law enforcement or you are state police. That's how you would go to put in a search warrant to then get fluff shit. Here you go. If you are the feds, you have a different route of going, and it is the relationship between the feds and a guy by the name of Boyd Jackson, who 100% was in his affidavit, and he says that Boyd Jackson's name is on the papers that he has seen in this case. Boyd Jackson does not work through GLDC. Boyd Jackson handles other things, and he has the personal relationship with the FBI to get them shit that local law enforcement is not going to get. This is why when the local law enforcement peeps like Mowry and Payne were and Ashley Jennings, for that matter, were filling out these search warrants, they were then supplying them to FBI and having FBI give them and turn them into AT&T. Why? Because FBI has this fucking personal relationship where you can get shit that the locals in the states can't.
It was the tower dump from the night of the murder, asked within the 7 days.
And didn't they preserve it? And didn't they preserve that?
that?
She says, I understand that. She says, I understand that. And I don't know if Ansel got confused here.
So where's the evidence that Mr. Koberger's
And I have a hard time thinking that she's getting confused here when she'd be working with Cy Ray, who is going to explain how this is going to play out. Okay. But you know what? I mean, if you're just being told something and then something is thrown at you and you're like, wait a second, because maybe he's fucking confusing her. Hippler over here is confusing her. Okay. But he says,
timing advance records from AT&T were available to anybody in December without a prior.
wait, what? Where's he getting this from? Hold on. Preserve it? Didn't they preserve that?
Okay. So where's the evidence that Mr. Koberger's timing advance records from AT&T were available to anybody in December without a prior request that they save those?
Right there. Where's the evidence that Brian Kohlberger's December 2022, it's the same way that the 3,800 were got. He's saying that the only reason the 3,800 were received is because they went through GLDC, okay, and they didn't. I call bullshit on that. They didn't. They could not go through Global Legal Demand Center at all in 2022 to get any of this shit because they couldn't get it. Because Global Legal Demand did not give it out until 2023 in June. So the question there is, Hippler, if you back up, he says, and Ann just says, I understand, and
people's timing advance
Because they were asked,
or I'm sorry, it was probably by
and yet you've provided no factual basis, zero, that evidence existed for them to be able to obtain it in December.
Your Honor, in April of, or I'm sorry, it was probably by the July date that I got it, of 2024, I got records from 2022. In some other time in 2024, I think it was May, I got 3,800 people's timing advance
Because they were
records.
asked within 7 days of the date that they sought it.
right there, boom. Because it was asked, who told you that, Hippler? Who told you that? Where is Hippler saying that? Like, where's he getting that information that you got that Jennings over here was able to get 3,800 of the people's phones on the AT&T towers through Global Legal Demand Center because it was within 7 days. Who gave you that information, Hippler? Ashley Jennings. So let's go back to, because it's all about going and looking at what we got here. If you go look at Ashley Jennings, and it's the state's motion that she put in, states timing advance. Here we go. Okay. Regarding AT&T, before June of 2023, AT&T retained timing advance records for 7 days. These records were not routinely provided in response to legal demand prior to June 2023. After June 2023, AT&T started providing these records pursuant to legal demand and began retaining timing advance records for 13 months. Regarding AT&T, before June of 2023, AT&T retained timing advance records for 7 days. This is Ashley Jennings. These records were not routinely provided in responses to legal demand prior to June 2023. After June 2023, AT&T, it was the 13 months. But she doesn't say in the first sentence regarding AT&T, before June 20th, 2023, AT&T retained timing advance records for 7 days. It doesn't say like from GLDC or anything like that. It just says period. In this case, the homicides occurred on November 13th, 2022. Brian Colbert was identified as a suspect December 19th. Search warrants for his AT&T records were executed on December 23rd, 2022. At this point, timing advance records were not available for Brian Colbert's phone to cover the relevant time period, November 13th, 2022. Despite defendants' repeated assertions, the fact of the matter is that AT&T did not provide timing advance records to law enforcement for Brian Colbert's phone. The state is attaching affidavits from AT&T verifying that the state did not receive timing advance records for Brian Colbert's phone. Now, based on the above statements or by the defense counsel or their witnesses that there is additional timing advance or that there's additional evidence that could have been provided or was not provided is simply not correct and should not be allowed. Remember what Ann Taylor wanted to do. Ann Taylor wanted to do what? I want to voidar, as he says it, who? None other than balance, right? Let me show you why. I, Stephen Gordon, AT&T maintains records. First of all, let me put where he is. I am qualified to authenticate records responsive to attached search warrants dated 12/22/22 because I am familiar with how the records were created, managed, stored, and retrieved. I further state that AT&T maintains records made at or near the time of the occurrence of the reference matter. AT&T provided records for the phone number responsive to the reference search warrant dated this. For records between November 12th, 2022 and November 14th, 2022 at 12 a.m. to 12 or to November 13th. Okay. So that was just the normal like CDRs. All right. This is like your regular phone. Here you go. This is who they call. This is who called them. AT&T did not provide timing advance records for phone numbers or for this phone number. Timing advance records were only available if requested within 7 days of the specified time frame. Timing advance records were not included in AT&T records responsive to the reference search warrant because more than 7 days elapsed between this date and this. All right. Now, this is all about Stephen Gordon. Okay. So this is where Hippler is getting his 7 days from. Hippler is getting his 7 days from Stephen Gordon, who is the director of GLDC. Now, I don't know if Ann Taylor, if Ann Taylor was told, remember, we are in a simple battle here, which is we just need an order to get and be able to cross-examine or void our Nicholas Balance. Okay. That's the goal here. We are not here. We are not here to argue our case and to show your hand. Do not do it, Anne. Do not do it. Okay. So it is very important to understand that where Hippler's getting this whole 7 days, yes, that is from Stephen Gordon, and he is not who Boyd Jackson is. Boyd Jackson is not Stephen Gordon. Stephen Gordon runs GLDC. That's how they got to do it. Now, Cy knows because he's worked with Boyd Jackson and he saw that Boyd Jackson's name was on papers. In this case, Boyd Jackson's name was on papers in this case that got turned over in discovery. And so when Cy is going through the discovery and he sees, holy shit, wait, you guys got this from Boyd Jackson? Boyd Jackson doesn't handle legal demand. This is from the FBI. This is their private relationship. This is how, when I got all the stuff that I did back in 2021, okay, and saw how they could get these timing advanced records, and it was through this Boyd Jackson and the personal relationship that then the FBI had with AT&T, and because it was way too expensive, whatever, that they just dealt with the feds to get certain things, you had to go through the feds, okay? This is why all of the phone search warrants, they went from Ashley Jennings in Moscow writing them up, getting the language from Nick Balance to put in them, okay? Make sure you put timing advance, make sure you use this, and then send it back over to us, and then we'll submit it for you on your behalf because we're going to get X, Y, and Z that you guys can't get because I'm going to go through Boyd Jackson. And Boyd Jackson's going to get me. Okay. So here we are. And what's going to end up happening here is that Ann Taylor wants to be able to ask Nick Balance 3 questions, which is, and we're going to find out who is going to lie for who. Okay. Boyd Jackson is going to be subpoenaed. Boyd Jackson is going to testify. I'm putting my, like I said, all my chips were in once I saw how this all laid out, and I said, they're all in. Who's going to lie for who? You think that certain people are going to lie? Is Nick Balance going to lie for Ashley fucking Jennings? Let's say he does. Let's say he doesn't. Don't give a fuck. Boyd Jackson, did you supply Nick, whoever in this case, with the timing advance for Brian Kohlberger for this phone number? The answer is going to be, we'll see. We'll see, won't we? The 7 days is with GLDC. So go sit and spin. That's where the 7 days is. But what's interesting is that why is Hippler, he's taking the word of this affidavit, Stephen Gordon, saying that Stephen Gordon writes in here, and you see the name Stephen Gordon. Well, Ray writes in and he says, I'm investigating this case. I've been in the investigating team, and I have documents that are from Boyd Jackson that have to do with this case, not Stephen Gordon. Boyd Jackson's name are on the printups that I have. Boyd Jackson works for AT&T, and he works in a different department of AT&T, and he provides records to the FBI. And if Hippler is just right in front of him, when he tries to tell Ann Taylor, hey, this whole, what proof do you have, or what evidence do you have, or what, the 7, and then he's talking about 7 days and blah, blah. He's like, Ann Taylor just had to say, because he's talking about like this case. In Ray's affidavit, even if she wants to touch on this, but maybe they talked and he said, don't do it. But if you look at the affidavit that Ray said, we don't have Stephen Gordon on the piece of papers that were, remember, inadvertently sent to us. We have Boyd Jackson's name. But we don't need to take care of any of that now. We're going to take care of that. We just need you to let us cross-examine Nick Balance. Because Nick Balance's own work product will prove and show that they had Brian Kohlberger's timing advance records. Why do you think the 7 minutes is now available for them for the state to have mapped this new 7 minutes? Where'd they get those 7 minutes from? If they didn't have Brian Kohlberger's timing advanced. Where's all that stuff coming from? So then you go back to here, which is,
It was the tower dump from the night of the murder, asked within the 7 days.
and didn't they preserve it? And didn't they
I
preserve that?
understand that.
Okay. So where's the evidence that Mr. Kohlberger's timing advance records from AT&T were available to anybody in December without a prior request that they save those?
Well, I don't know if they made a prior request that they save those.
Well, they wouldn't, because they didn't know who he was.
That's their timeline.
You're correct. They didn't know who he was until I think about December 19th. Their warrant for his full scope of records, the second AT&T warrant, asked for all of the records. I haven't seen any of them. That's even if they were just the 7 days back, I haven't seen any of
What
them.
you're talking about now is a discovery issue of those 7 days that don't sound like they're particularly relevant to the murder.
Look at how, don't sound like they're particularly relevant to the murder. What? She's had so many motions to compel this fucking shit. And they've said that they do not exist. They do not exist. They do not exist. She as in Ashley
It's a
Jennings.
discovery issue you can take up with the court through a motion to compel, which you have not filed. It's not
And
an
you're gonna have to give it
arbitration in
up.
which you can lay down Mr. Ray's conspiracy theory without
Conspiracy
any
theory.
evidence.
Your Honor, we have litigated this issue quite extensively throughout the course of the case. The timing advance records, once I understood how timing advance works, became very important. We've heard different things now than I've heard at different times in the past about.
So right here, what she's saying, we've heard different things now that I've heard from in the past. And what people think that she's referring to is, I'm telling you, how she means that is, we're hearing different things now. We heard that these timing advance records didn't even exist. Now, Ashley Jennings got up there and is talking about timing advance records.
Particularly about the 7 days. That's newer information to me now. But the carrier request forms tell me I should at least have that. I want the court to know that we have had motions to compel on this very issue. We have had different bits of information.
For the 7 days that are after December, in December?
No, Your Honor, because the 7 days is something that's newer and has been brought to my
Our
attention more
motion to
recently.
compel related to timing advance records for November 13.
Our discovery requests were for all of Mr. Koberger's timing advance records. Our motions to compel covered all of them too. I have this carrier request now that says 7 days, and I have the affidavit now that says 7 days. Those are not things that I always knew when we were litigating this issue.
Okay.
Those are new bits of information. To me, it is a little bit problematic that there's been things that have changed and there might be records out there. Given what you have now with the affidavit with 7 days, if you imagine you didn't know that, and you
I understand your confusion and concern previously. What I don't understand it is now. In light of the evidence, I don't understand Mr. Ray's accusations without addressing the 7 days that he had that information when he submitted his affidavit.
he is available to testify if the court wishes for him to.
It's his obligation and your obligation to establish that evidence of that the state has this, and you haven't done that. His affidavit is quite extensive, and he seems to ignore that issue.
Okay. He does not at all. And you guys right here, I don't know, like I said, if this was strategy or if Anne wasn't understanding it. Okay. And you got to think about it. Anne's doing a million different things, right? Awesome. The answer to that is the way that I understand that whole 7 days is about the GLDC, whatever. And that's not what we're talking about. There's another way to get those, records. And my understanding is that it's through Boyd Jackson, and his name is on reports that we have. And Boyd Jackson does not work for Legal Demand. But that part of AT&T.
I believe that issue is touched on with his knowledge that these kinds of records existed a long time before.
He said that in a very general way about that without reference to the 7 days. And he supposedly received them from some FBI expert to look at for his company, and then was told not to use them. So I don't know, maybe the FBI got them in a way that they weren't supposed to at that time. For all I know, he didn't name names, he didn't identify it, he didn't put into.
That's a lie. He didn't name names, he didn't identify. Now, I want you to see right there. This is a lie. Ready? In Cy Ray's affidavit, he names Boyd Jackson. I showed you guys on my channel. It's in the affidavit. It says, I've investigated this case. Do you guys want to see it? I will pull up the affidavit. It says it right there. He says Boyd Jackson. It's all over it. He says, if you want the name of the FBI guy, okay, ask me. Ask me and I will give you all of that.
Right. Into
He said Boyd Jackson. What the fuck?
And that provided AT&T's sworn testimony that they only keep them for 7 days. And yet.
That's what Ashley Jennings gave. When they talk about sworn testimony, Ashley Jennings put those in fucking the 403B bullshit for fucking a while ago.
He makes the accusations that he did in his affidavit without addressing that 7 day issue at all. And so I guess my point is if you want to cross-examine the witnesses about why didn't they rely on the AT&T timing information, you've got to show some factual foundation that was available to them by the time Mr. Koberger was on their radar as it relates to November 13.
And that's why we want to ask him. We want to ask him that.
And I'm not seeing that as the problem.
And so I guess,
Question to Special Agent Balance, who would be the person who would have gotten these through a different channel through the FBI, would have been, did you get them?
right there, do you see how she says, I need to ask Detective Special Agent Balance, who would have gotten these through a different channel. So she's not even talking about like how, like I said, I don't know if Anne kind of fumbled this, okay? But let's just say that Anne fumbled this. So Lana, what would you do and say? Well, I knew the affidavit inside and out, and every time that homeboy's asking me a question, and if it's not part of my strategy, and if I'm supposed to be talking about this, which I think is part of strategy because you don't want to be playing your cards, but let's say that it's not, I would say, hang on a second. You're going off of Stephen Gordon's affidavit. Okay, is that what I'm understanding here? And that's where you're getting what Ashley Jennings wrote in her motion. Okay, and then she applied Stephen Gordon's affidavit, right? And then after seeing that, I'm under the impression that Cy Ray then submitted an affidavit after seeing that, okay? And he's saying that he knows Stephen Gordon, and Stephen Gordon has nothing to do with how Cy Ray is showing that he's found Boyd Jackson's names on reports, and that comes from a different relationship with AT&T, and that based on that, they're able to get the timing advanced way before. So Stephen Gordon saying that he didn't give any timing advance data up, they didn't in this case. They didn't. Within regards to the whole tower dump, which is, I think, completely different because that's like a geofence, but that's just me. I would have to see more, I think, of the discovery to make that like, but it's clear as day in the affidavit that the person that we need to be asking here is Nick Balance. Did Nick Balance get these? And based on Cy Ray's, or we can bring in Cy Ray as well, because he's seen the information and he'll tell you he'll show you his evidence. He says he has the evidence, he has his exhibits. So I don't know it like he knows it. That's why I was relying on him. So I would have him be testifying. Why Hippler is refusing to let Cy Ray testify, that is what everybody should be asking. If you were Hippler, why wouldn't you want to nip this right in the butt and say, yep, bring your ass on out here? What's his name? Richard Allen's motion limines, those were like 3 days. 3 days, and they had tons of people testifying at that proceeding, okay, in August. And so to sit here and think why Hippler isn't going to let the same thing happen in a capital murder case for Ann Taylor to be able to call this person. And this is why he just wanted to make a big deal about this. Shut the hush up, I guess. Bide time, in my opinion.
Because I've heard different things along the case, asking him a question is really what I wanted to be able to do. And that's why I opposed this motion and prepared it as I did.
Tell you what, I'll let you ask that question outside the presence of the jury at the time of trial.
That will satisfy me. Thank you.
Yep, she's right. That satisfies it.
And I'm not.
And that'll satisfy me. Again, what I'm totally confused about is Ann Taylor, like literally the first sentence that comes out of her mouth is, I am just here to make sure that we are able to cross-examine Nicholas Balance, because my opinion, I don't believe that Nicholas Balance, if he chooses to lie, I believe that it's going to get blown up. And so Nicholas Balance has to make a decision if he's going to lie or not. Okay. Are you going to lie? Is Nicholas Balance going to lie? Because then listen to what happens right here. Then a little ticking time bomb goes off in Hippler's head, because I think he's wondering, why the fuck isn't Ann Taylor giving me what I want and what I need right now. Okay. So a little birdie goes off in his mind. And so this is what he does.
Except, but I just for Mr. Ray's information, because he wasn't here the first day I started this trial with you folks. I said, I don't want theatrics. I don't want accusations that aren't supported with evidence about supposed bad conduct of the parties. You're all professionals. I respect you all. And the accusations he made in there are very concerning. The kinds of accusations are true that would get people disbarred. And so without any evidence and apparently sidestepping the clear explanation, he makes those. And so that doesn't.
See, I told you guys, this is those accusations would get you disbarred. And it's so him just making that statement right there then too, if it then becomes true, you have a judge saying that that's what can get you disbarred.
Doesn't make me happy.
So if it can get you disbarred, don't you think it can get a case tossed?
And to address the court's concerns.
Exactly
posed
what
by
they're
some of the
disbarred,
information
wouldn't
out there, I have the 2 search warrants. The state asked for the AT&T timing advance records in our search warrants. The state wanted that information from Mr. Koberger. We did not receive it. I did not receive those records from AT&T. I do not have them. Thank you, Your Honor.
Right. There's not been a showing that those records were available. And I think it would be unfairly prejudicial to try to impeach the testimony of the agent that somehow he hid or didn't provide or didn't use records that he didn't have available to him. So absent some factual showing that he had them available, I'm not going to allow questions about that. And I'm not going to allow testimony about that. Now, if you want.
That would be prejudicial. That would be prejudicial. Wait a second. If we just show, if we're saying that they were actually available, right? This is what he's saying is prejudicial for, what if they were available, but he just didn't go get them? I'm not going to allow that. I'm not going to allow that. I'm not going to allow that. Because what is prejudicial about it? What's so prejudicial about asking if, what if he's done it in a different case? What if he's done it in a different case? So then why wouldn't you do it in this case? You know what I mean? Like if, but he's gonna let in a, you pulled him over for fucking for a seatbelt. That's relevant.
You want to voir dire?
Okay, right here. You want to voir dire
Him before he testifies in front of the jury? I'll allow that. And if you show a factual basis for it, I'll allow it. But you haven't at this point.
I appreciate the opportunity to ask a question outside the presence of the jury. Thank you.
Thank you.
Oh, this is up the stakes. Oh boy.
All right. The vague and undisclosed expert.
Really quick, just my 2 cents here is, whew, everyone's dying on their own hill. Everyone is dying on their own
I'll
hill.
let you talk about the other entirely part.
Yes, thank you, Judge. Then you'll get a break from me in a few minutes, I think.
I enjoyed dialoguing with the council. I appreciate it.
Well, good. I think we're going to have some time together over the next 6 months or so.
Okay, so
Your Honor,
then
this-
here, this is
motion-
the,
Came after our hearing in January, and we're asking the court to limit what the state can produce with their experts here.
about Nick Balance. I'll watch this.
At least we're fact people on the ground making decisions about the investigation. Now, in today's world, as the state pointed out, there's an over disclosure of fact witnesses as potential experts so that they're not caught in the situation the lawyer was with the drug recognition expert with the state police when it was determined, well, he was offering an expert opinion about something in that regard.
So
You're doing this in the frame of a motion related to the expert disclosure. And so his opinion is what his opinion is, and he's disclosed what he's disclosed. And let's just hypothetically say he can't opine about the last 7 minutes because he hasn't disclosed that. And I haven't gone through in enough detail to make that conclusion, right? Isn't that then just a matter of you putting on testimony?
He already opined on it in the probable cause, and
teaching him about,
say it.
you didn't even look at the last 7 minutes.
He's already opined on it.
And what could that mean? Couldn't it mean as my expert, obviously your expert won't have testified by then, but impeach him essentially on his lack of diligence, as you would put it.
well, I anticipate impeaching for the lack of diligence. Here's the fear, though. I don't know what he's going to say about those 7 minutes, so I want to impeach him about that. I want to impeach him about a whole lot more too. But if I do, and he says, well, I did analyze it, actually, I hope the court's order stands, and he's not allowed to talk about it.
Yeah, be careful about what doors you open. But
I agree, and when the court said that, it made me think of that. Going back to what I'm asking you
rules.
to exclude, I'm asking you to exclude everything that wasn't contained, and there's no opinion, there's no analysis contained in that original PowerPoint. There's just PowerPoints with a few things on them that he won't be able to explain because
They did supplement and explain, at least in some detail, more about what each slide kind of means, as I understand it.
well, Your Honor, that comes back to kind of where we started with the state waiting to see what we had. That's not how this works. In the adversarial system where the prosecution has the burden of proof, we can sit at the defense table and do nothing. I don't have to produce.
Exactly. Now, we're going to start this though from the beginning because I don't want anyone to miss this point. This is about Nick Balance being an expert. He was also co-located and he basically was an investigator in this case, more or less. But until you actually talk to Nick Balance to find out what the fuck he did, you don't know.
Other entirely part.
Yes, thank you, Judge. Then you'll get a break for me in a few minutes, I think.
I enjoyed dialoguing with the council. I appreciate it.
Well, good. I think we're gonna have some time together over the next 6 months or so. Your Honor, this motion came after
This is where an aha moment goes off in Hippler's mind about the lies on the probable cause.
our hearing in January, and we're asking the court to limit what the state can produce with their experts here. I do have copies for the court, extra copies for the court. We had a specific request at the end of our motion. We called it Exhibit 1, and it went through all of the state's experts and basically described what we think the court should do with the state's experts. And so I wanted to provide that to the court. Okay, good. Thank you. We get to my same page. I want to, our motion for the court to exclude all of the state's experts as outlined in our exhibit is based in Mr. Koberger's rights to a fair trial, effective assistance of counsel, due process, and guaranteed by discovery rules and rules of evidence and the court's own scheduling order.
It's rooted in Rule 16, which is kind of where the court looks at these issues.
Rule 16 it is, yes, Your Honor. This started with discovery requests very early on where we asked for expert information from the state. I'll skip forward to the court's scheduling order, which was very clear about what should happen and that we needed to have our expert disclosures in at a certain time. The state's date was December the 18th, and shortly after we received the state's expert disclosures, we filed a motion to compel. We wanted the rest of their disclosures. We had a dialogue in January about that, and the court asked me, why are you doing this? I'm going to make them abide by the rules, by the discovery rules. I really thought when we filed that motion, the state would say, oh, okay, and we'll just get you the information. Most of these are experts they've been working with all along. But that's not what the state chose to do. The state chose to say, nope, I'm going to dig in my heels, and we did plenty until the court said your job is not done.
I'll be fair. In the way I handle these issues with Rule 16 in the context, the rule is not particularly broad about what is required. And the court has interpreted that rule fairly narrowly in other cases. I give the speech that I gave to you both in most cases where there are a lot of experts to encourage sharing beyond that which is required, because I think it helps both sides. And I think it helps the experts be better prepared to testify because counsel understands their testimony better. I think it allows for cross-examination better. And I think it creates just a more fulsome picture of things that way. And that's why I invited the state to supplement. I also invited you to be likewise broad in your disclosures. Now, at the end of the day, I am bound by Rule 16. And so that is my guidepost.
Well, Your Honor, I believe Rule 16 references the Idaho rules of evidence. And I believe that the state's requirement is to provide at least the opinion that their expert is going to offer. And case law, the State versus Moran case, says that bare lists aren't good enough in this case. Your Honor, the state didn't immediately file and fix the issues that they had, but we filed our disclosures, and our disclosures weren't bare bones. They were exhaustive in method and analysis and opinion. And the state gained an advantage when it happened that way. The state then went from having their experts due on December 18th and really setting the bar. We have the burden of proof. This is what we're going to do. These are our experts, and this is how we're going to do it. They went from that place with their duty and their obligation to giving minimal, which were just lists other than a couple of their experts, and then receiving all of ours. And you can see in the next bit of pleadings that really shaped what they were going to do. When their rebuttals came due, they got an extension until February 17th, but that didn't see them fixing the problem that they had in large part. Some reports came in March 3rd, some March 14th. So the state has effectively given themselves months of additional time and the advantage of having our expert reports. And that just can't be when you're looking at fairness of trial, when you're looking at who has the burden of proof, when you're looking at due process. The state is to say, this is what we have, this is how we're going to prove this case, and for us to decide how to respond to that. And that got turned upside down with what the state has done here. They held back, gave us bare lists in large part, and then had the advantage of having all of our work, how we would anticipate we might rebut the state's evidence, and allowed them the advantage of deciding what to give us and when. It is extremely difficult when the state gives things just a piece at a time to us. It is extremely difficult when we have a deadline and we have plans, we have our experts, we have our schedules with our experts so that we can continue to prepare as we head towards trial. To have the state act in this fashion, to hold back and then to give things little bits later without even giving a full expert analysis in some cases. The court has the duty to ensure that we have a fair trial and that Mr. Koberger's due process rights are adhered to. And the court should exercise its discretion and apply the rules and limit what the state is able to produce as far as their experts. I'm going to talk a little bit about the different experts here. They are outlined in Exhibit 1. I don't think I have to go through every single one. We try to be pretty clear for the court if the court looks at that when considering our motion. But I do want to talk about a couple of them. And obviously, Agent Balance is the one I'm going to want to talk about. Your Honor has heard some things about this disclosure. I can't call it a report because it's a PowerPoint. I don't know what Agent Balance's conclusions are. And Agent Balance doesn't, the PowerPoint obviously isn't going to be complete. PowerPoints aren't designed to be complete reports of what happened and what somebody thinks has happened. We've had several different disclosures now. They don't help much. On March 3rd, for the last time, we learned that Agent Balance acknowledges he analyzed the last 7 minutes of data on the phone, but we don't know what his opinion is about any of that.
To give an opinion about those last 7 minutes?
I'm sorry.
Doesn't that just mean he's not going to be allowed to give an opinion about those last 7 minutes? I mean, I can't force his expert to have an opinion.
Okay, right there. Doesn't that mean he's just not going to give an opinion on those last 7 minutes? Sorry, I wanted to go fast with it. Can you fucking believe this? Okay, let me get this straight. Doesn't that just mean he's not going to be able to give an opinion about those last 7 minutes? So how the fuck would you, Special Agent Balance, did you provide information to Ashley Jennings or the police that said that Brian Kohlberger's phone was shut off at 2:42, 2:47, whatever the fuck time? Do you understand that if he answers that with a no, you didn't supply that information like to Officer Payne. So okay, so let's talk about your report then. You understand right there that's a lie? Because Payne said that that's what Nick Balance told him. Okay? And that's how Hippler concluded it. Like, I don't think that Officer Payne lied here. He was just writing down, what the expert was telling him from the data. Okay? And so it's all on the shoulders of Nicholas Balance of what the fucking phone was doing at the time. Okay, during the homicides, right? So then it's like, okay, well, if he's not going to opine on the 7 minutes, because he just says, well, doesn't that just mean that he's not going to, he just can't give an opinion of that? What? Are you aware that Brian Kohlberger's phone doesn't shut off or go out of service when you believe that it did back 2-3 years ago? Like, how does this even fucking work?
You can't. And we're here asking you to limit what they can testify to by surprise once we get to jury trial. Agent Balance is worth further comment to the court. Agent Balance was co-located with investigators in this case from the very early days, just a couple of days after the killings took place. He is somebody that the prosecutors have had meetings with and have had ready access to throughout the course of the proceeding. So it's not like he's a stranger that they couldn't get his report from him. He has offered his PowerPoint with no analysis of these phone transactions, no analysis of the mapping that was done. And to understand that, he conducts drive testing and he carries around a scanner when he does his drive testing, and that scanner will collect data about which towers are working at that given time. So you can get a lot more accurate information about where a device might be. The other way to look at what devices are doing is when you're looking at different cell towers and the phone transfers from one to the other as the phone might move around in a car. But the drive test data working with that shows you a place where there's a tower, all the places that there might be coverage. And then if the phone hands to the next tower, it'll show you that coverage too. So you can see limits, you can see gaps in where coverage is, and that helps you identify where a phone is more. Agent Balance hasn't analyzed all of the data he collected, nor has he told us what it means. So for Agent Balance, the court should preclude his testimony about the last 7 minutes, and the court should preclude the rest of his testimony, really. I think the state's initial...
Right there, she nails it. Because why she says that you should preclude his whole entire expert opinion or whatever the fuck he's going to testify to, because how does this even go about? Because it's going to confuse the jury. He gets to testify on direct with the state to a bunch of shit that's not accurate. And then I have to come back on cross and literally go, like, I'm going to out the fuck out of him to say, okay, you were co-located, right? And you helped write a search warrant. And it was your information that was used to plot where this phone was, right? And now come to find out, now you don't have an opinion on where this phone was for the 7 minutes that you said that it was off. Now you just don't have opinion about that. This motherfucker shouldn't be able to testify at all.
Disclosure was that he was going to talk about cell towers and how they work with cell phones. That might be fine. Anything else, they shouldn't. I want to tell you though,
He can talk about cell towers and how they work with the phones.
while we're on the topic of that last 7 minutes,
that'll
that
be
is
fine.
more problematic.
That was part of the initial disclosure.
Okay, here we go.
PowerPoint, the PowerPoint I believe was provided as a disclosure.
Did he testify before
Like-
the grand jury?
No, nope. Agent or
Right-
Officer
right
Mallory,
here.
Detective Mallory testified before the grand jury.
Oh,
Agent Balance
boom.
did not. So I don't have any of his testimony, but I want to tell you about the 7 minutes. And I want to tell you that those are problematic. When the phone's moving, when Brian's phone's moving the last 7 minutes before it goes off the network, and you look at the locations of where the phone was, it places the phone in a place at 2:54.45 in the morning. And for Agent Balance to ignore that, there's a cascading impact on other bits of testimony that will come in. So it's imperative.
Casket, yeah.
Well, it's actually exculpatory to Mr. Cobers, so it's worse than that. So
You're doing this in the frame of a motion related to the expert disclosure, and so his opinion is just what his opinion is, and he's disclosed what he's disclosed. And let's just hypothetically say he can't opine about the last 7 minutes because he hasn't disclosed that, and I haven't gone through in enough detail to make that conclusion, right? Isn't that then just a matter of you putting on testimony?
He already opined on it in the probable cause, and
Teaching him about
okay, so right here's where I get fucking Liddy fucking pissed. I'm like, wait a second. He's already opined about it though in the probable cause. Okay, like wait, but he has already opined about it in the probable cause. He just hasn't opined about the 7 minutes, in his fucking to write up an actual fucking report about the 7 minutes because we want to put him on the hook, motherfucker. Why isn't Payne or Balance writing up his report and putting himself on the hook for what he's saying?
about
Say it.
you didn't even look at the last 7 minutes.
He's already opined on it.
And what would that mean? Couldn't it mean as my expert? Obviously your expert won't have testified by then, but impeach him essentially on his lack of diligence, as you would put it.
well, I anticipate impeaching for the lack of diligence. Here's the fear though. I don't know what he's going to say about those 7 minutes. So I want to impeach him about that. I want to impeach him about a whole lot more too. But if I do, and he says, well, I did analyze it actually, I hope the court's order stands and he's not allowed to talk about it.
Yeah, be careful about what doors you open. But
I agree. And when the court said that, it made me think of that. Going back to what I'm asking you to exclude, I'm asking you to exclude everything that wasn't contained. And there's no opinion, there's no analysis contained in that original PowerPoint. There's just PowerPoints with a few things on them that he won't be able to explain because
they did supplement and explain at least in some detail more about what.
Supplement? What the fuck is he talking about? You can supplement. What don't you understand about a deadline? So you can supplement when? This has been 3 fucking years. And this is what I'm saying. No, Your Honor, he opined in the probable cause. The probable cause saying when Officer Payne's writing this, this, and this is what he opined on. Then, is his opinion changed? The fuck?
Each slide kind of means, as I understand it.
well, Your Honor, that comes back to kind of where we started with the state waiting to see what we had. That's not how this works. In the adversarial system where the prosecution has the burden of proof,
They wanted to see what Cyree was going to say.
we can sit at the defense table and do nothing. I don't have to produce a thing.
Thank you.
They have the burden always to prove the case. And what they've done is they've turned that upside down. They've essentially and figuratively shifted the burden by holding on to what they had, even though they have the duty, and said, show us yours first, and then we'll rebut your experts. And that's just not the way it works. And I think the court should look at their disclosure deadline. And they didn't go home from the January 23rd and 24th hearing when the court said your job's not done. I'm not going to allow things in that aren't disclosed. They didn't go home and say, we got to get this done now. They trickle things in bits at a time. And that is just not the way the system works. And that's in violation of Mr. Koberger's rights. And we're asking the court to limit it. What they gave us on December 18th, that's what they get to talk about. There was no opinion in there, no real analysis in there. And that's our position. And that's the way to bring it back and keep the burden at the table it should be and protect the due process rights and the right to a fair trial at the table it should be. In our filing, I won't read it all to you. They have a lot to say about that with Agent Balance.
Warrant application include the analysis.
Right there.
Self-evident.
Ding,
Yes,
ding,
yes,
ding.
yes.
Yes, right. So right here, remember I told you here's going to be the bomb. I want you to take a look at fucking Nye, okay? I was like, this is what I'm going to be leaving you guys with. Watch this, okay? Here we go.
In our filing, I won't read it all to you. They have a lot to say about that with Agent Balance.
Warrant application include the analysis of the cell tower information.
Yes, Ann. Here's your chance. Do you see fucking Nye put his head down and go like this. Motherfucking boom. I'm going to play it for you one more time. Nye is the guy sitting next to Ashley Jennings.
Agent balance.
Warrant application include the analysis of
Fair trial at the table it should be.
Okay, here we go.
In our filing, I won't read it all to you. We had a lot to say about that with agent balance.
warrant application.
Did the search warrant application, did the search warrant application
Include the analysis of the cell tower information.
Yes, Ann. Here's your chance. Right there. Do you see him? He's like, fuck. Here we go. Here we go. And that's where I'm just like, fuck yeah, here it is. And it did. Okay, so this is what I was screaming. Like, did the search warrant application include the cell tower? And it's, let's see what Ann Taylor does.
Did the search warrant application include the analysis? Let me think what the search warrant application said first.
Large, omnibus document that they used
Oh, exhibit one.
Oh,
that was
yeah,
attached to
yeah.
all of them.
Yes.
to, if not the signatory, but the FBI cast team.
Yes, this is what I was saying.
Well, we're talking about a couple of different parts of the affidavit. There was the factual part of the affidavit that Moscow Police Department, various members of the police agency used it, the same affidavit or a couple different versions of that same affidavit. There was a part that I don't think Nick Balance ever signed it. I think he
My point is
dictated
that
it.
Were you on notice of what the state's version through the cast team of what that data showed?
If I look at the affidavits, there are a few things, yes, that
Okay, so this is where I think, I don't know if she's doing this on purpose because this can't talk, or she fucking literally blew it. Because it's like, here, yes, exactly. Like, Nick Balance's shit is on page whatever the fuck, 12, 13. And it says that the phone was moving to reporting to the cell tower, then it stops reporting at this time. That information 100% came from Nick Balance, okay? Payne testified that it came from Nick Balance. Okay?
I would be on notice for. They're not attributed to Nick Balance, but there are a few things.
They are attributed to Nick Balance. And I don't know if maybe she's just saying this, but Hippler attributed them to Nick Balance and not to Officer Payne because it was a fucking, everybody was working on the document. And when Payne testified, he testified and said, I am not a cell phone expert, so I relied on da-da-da-da. And who helped you with that? Da-da-da. And the name is Nick Balance.
Those are the problem areas, and I don't want to open doors that I shouldn't. I mean, I either need his analysis if I'm going to open the door, or he doesn't get to talk about it. And let me tell you what I mean.
The adversarial part, I also looked then in that case at what information you did have about what the state's case was. And so, you know, it seemed to me that in general that cell analysis was part of it, because part of the motion on your part was the missing 7 minutes.
That definitely was part of the motion, and now for the
Yes,
first
he's
time, I know
helping you
he
here,
actually
Ann.
Analyzed it.
Yes, this is what I was saying.
What that affidavit, those two affidavits, I would tell you about 3 parts that could be attributed to any cell analysis. And then I'm going to tell you the problems with those 3 parts too. The first is that the phone went off at 2:47 a.m., which it did not. It did not. That's untrue. The other is that the phone was traveling towards Moscow when it went off, and that's absolutely untrue as well.
I recall the 247 said it was traveling southwest.
Well, that's what we say. That's what the record shows.
That's what the application said.
Yeah, but the
The
time's wrong.
application said that the phone stopped reporting to the network at 2:47 a.m.
Traveling southwest at the time.
That's what the protocol says. The why of that decision has been something that we learned about for the first time in the February 17th disclosure. That was curious.
My point is, I don't really view that as that as expert testimony. That is simply the underlying factual happenings. It's like, why did you then make a phone call to this person? Well, because. I mean, it doesn't make it an expert opinion. In my expert opinion, I thought it'd be good to call this person.
Oh my fucking God.
For,
Are you understanding what the fuck just he said right there? Back in January, he's over here saying the opposite thing, that Payne is relying on the experts to fucking, and then he's over here in fucking whatever month we're in, April, saying that I wouldn't consider that relying on the experts. Is that right, Ms. Hibbler? This is insane. Like, what? I don't consider that expert testimony. Well, no shit, is that expert testimony? No, he didn't testify to that, okay? But it's his fucking expert opinion, all right? Because just like Immel and them, you're saying that I consulted with the fucking, you know what? Fuck all this. We're just going to go straight to the damn document. Everybody can just get royally bent. Just go to the document, click on Brian Kohlberger, click on 2000 and fucking, what is it, 22, 23 it came out. Which is all the way back here. And it's the let's go back one more. We'll go to this one. Probable cause affidavit. Here it is. If I can spread it all the way around town. Oh, balls. Affidavit. The hell fucking page is this on again? It's stupid. Okay. Okay, page 13. I'll show you. Let's pull it up. Is that right? Is that right? Here you go. Affidavit. Boom. After receiving this information, I consulted with an FBI special agent that is certified as a member of cellular analysis team. Member of CAST are certified with FBI to provide expert testimony in the field of historical CSLI and are required to pass extensive training that includes both written and practical examinations prior to being certified with CAST, as well as the completion of yearly certificate requirements. Additionally, the FBI CAST SA that I consulted with has over 15 years of federal law enforcement experience, which includes 6 years with the FBI. From information provided by CAST, yeah, the CAST expert, I was able to determine estimated locations for, and then this is when we found out that no, actually, he didn't provide estimated locations for anything. He got all the information, meaning Payne, from this dude, Nick Balance. On November 13th, 2022, at approximately 2:42 a.m., the 8458 phone was utilizing cellular resources that provide coverage at 6:13 or 6:30 or 16:30 North, blah, blah, blah. At approximately 2:47 a.m., the phone utilizing cellular resources that provided coverage southeast of Kober's residence, consistent with the 8458 phone leaving the Kober residence and traveling south through Pullman, Washington. This is consistent with the movement of the white Elantra. At approximately 2:47 a.m., the 8458 phone stops reporting to the network, which is consistent with either the phone being in the area without cellular coverage, the connection to the network is disabled, such as putting the phone in airplane mode, or the phone is turned off. That is what he said. So going back to Hippler, now Hippler then says, what did you talk about again?
Fact people on the ground making decisions about the investigation. Now, in today's world, and as the state pointed out, there's an over-disclosure of fact witnesses as potential experts so that they're not caught in the situation the lawyer was with the drug recognition expert with the state police when it was determined, well, he was offering an expert opinion about something in that regard. And so you get a lot of fact people disclosed in expert disclosures, but I'm not sure how, because there was a lot of briefing back and forth on that, how the decision whether or not to send the stair rail DNA to CODIS is an expert testimony. It's just basically lab protocols.
I think as long as it doesn't tread into an expert opinion about that, we can.
What would that be?
I don't know. I haven't read one. I don't know. I mean, if they're having some opinion about what those spots on the handrail and the wall look like, I guess.
Well, I mean, I wouldn't expect to see at this point an opinion that, you know, it was the DNA of Y person, right? Unless there's been newly discovered evidence.
Well, I don't have any of that today, but I understand there's more for me to pick up, but I don't know what it relates to.
What's up? How are you there, Scotty?
With regard to the lab personnel, I think the best thing to do is keep them to their lab reports and the disclosures that are explanation.
Bottom line, guys. There's an IgG baby, and there's a motherfucking huge Nick Balance baby. And this was a motion in limine, period. This was not opening day of trial. This is like Judge Hippler on his own realized and says, oh my God, wait a second. What was in that probable cause affidavit again? A complete fucking lie. An opinion. Why would Nick Balance think that the phone was turned off at 2:47? Okay. Because this is even what's crazier, right? Is that it's not like they wrote up this. So here, they have the phone number and they're thinking that this is what's happening, blah, 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 right? Then they say, okay, well, if you have information though that shows that because you did all these driving tests and then you have good old Brian Koberger here, you have his phone number and you're just like, wait, if his phone really didn't turn off until 2:54, why would you ever want to, why would you care? Why would you say, okay, we have to say that it shut off at 2:47, right? Well, because we have this white car that we want to claim that's Brian Koberger's and it's heading one way. And holy shit, we have a camera here. And if the car really did turn around and go a different way, like Ashley Jennings says, like, well, cars can just turn around. Well, if it was heading one way, we don't want to show that though. We have to just cut it off perfectly to show that it's still heading southbound, where it can then make a decision on 270 to, you know, go out towards Moscow or whatever. Not if you have the timing advance records all the way to 254 to show that there's no way that it continued from 247 until 254 on this alleged path that you're trying to claim. So the path from 247, in my opinion, to 254 shows a strong, heavy deviation from whatever the fuck is in this probable cause affidavit, right? But now the question's going to come out is, when did Nick Balance have the timing advance records, and did he know this back then? And if he knew this back then it's over. It's over. But the question is Brian Culver then, you know, is he guilty? Is he going to get away with because it's a technicality? Blah, blah, blah. I don't know that. I'm just straight up showing that this is what you call railroading somebody. When you take the evidence and you make something that isn't there to bolster your case against somebody that you know did it, but you can't prove that they did it, but we're going to get this son of a bitch anyways. Okay? Or it's way worse than that, which is we're going to frame somebody. Now, don't know. At the end of the day, it doesn't matter, according to Ashley Jennings. At the end of the day, Brian Kohlberger is just guilty at the end of the day. So none of this matters, according to Ashley Jennings. I think this is awful. I think this is absolutely awful for the victims. Absolutely awful. Absolutely crazy. I think we all saw Nye's reaction when they talked about the timing, or when they talked about, oh, wasn't this in the probable cause affidavit? Absolutely it was. And I have no idea if Ann Taylor was asleep at the wheel. I don't know. But that was a really, really, I think I would have taken my moment. Unless, like I said, you want to wait till the jury is sworn in and then you do something like this, it's automatic jeopardy is attached and it gets tossed. And it's double jeopardy then if you try them again. So you heard here first that the only way that you'd be holding on to any of this is so that double jeopardy attaches when you start the trial. And that so some of this stuff you don't want to come out now because you could cure the issue. I just think Hippler's own rulings prove that Hippler doesn't need to sanitize anything. The state doesn't need anything sanitized. They don't need a generic tip because according to Hippler, as it should be, either they get the Franks hearing because it's all fucking lies, right? Or since you didn't award the Franks hearing because you're going to believe this bullshit, then you have to let them ride with the bullshit. Okay, it doesn't work both ways. And this IGG baby it's fucking coming out the canal, man. It's crowned right now. And someone needs to go in there and get that fucking IGG baby. It's here. Same thing with Nick Balance. Nick Balance is the daddy of the IGG baby that nobody knows about. Okay? It's a fact that Brian Kohlberger's phone did not shut off at 247. And it's a fact that Nick Balance knew that. And so Nick Balance let, in my opinion, them lie. Or he's going to testify that he had no fucking idea that that's what was on the probable cause affidavit to arrest him. It's going to be really interesting on who outs who. Who's going to be losing some jobs? There's a way bigger issue here. Way bigger issue. And I think after you do the damage that I believe is about to happen, then that's where you have to start considering if you would go bench trial. There's no, I don't want my life in the hands of fucking 12 jurors right now in this time, what's going on in life right now. People can say, like, we just need one juror to hold out. We just need one juror. Fuck. We'll see. You could say it's never going to happen, that you wouldn't want to roll that way. Who wants to roll with a jury? Who wants to roll with a jury? Okay. He at least has to, like, I most certainly don't. Who fucking trusts this judge, right? No. I don't know. I don't know what's worse. I don't know. We'll see. Exactly. That's my. I sat in Richard Allen's case. We watched Karen Reed's case, and you want to roll. Let's see. Problem with the feds is that if they perjure themselves, it gets removed. It gets removed to federal court, and sovereignty claim would dismiss it. This case, 100 is going to top O.J. Simpson. This case is going to blow people's minds. This case is going to blow Karen Reed. You could take all the big cases right now, put them all on a ball, and say, here you go. This case is going to out some serious shit. You know, people thought it was bad that Michael Proctor was calling, Karen Reed names, right? Okay. Grainy video, 42 minutes missing, but you couldn't prove anything, you're going to be able to prove a shit ton here once Cyrade testifies and Nick Balance testifies. It's fucking going to be nuts. The roommates, 2 other perpetrators. This required 2 different weapons. It means you're going to have an Emmy talking about wounds. We're going to be talking about, it's going to be wild. I bet Judge, I think he's going to let the third party in. I think he 100% is going to let that in. Because the whole thing is, like, if he didn't do it, who did? And if you can prove that nexus, I think in Idaho, you're going to be okay. The 911 call didn't happen until noon. You have people in the house that were not murdered. Okay. And you have people in the house that were deleting. That is why Ann Taylor's probably going to have one of them be part of that, because it's a consciousness of guilt. We'll see. Thank you guys so much. Thank you for understanding my voice. My voice needed a big old rest. Woo. Appreciate you guys. Melissa, welcome. YouTube member. Shake it. Courtney. Circus music. Thank you for all that you do. Thank you, $13.99. Appreciate that. Sister stylist. Imagine if Lana was a lawyer. Fuck, if I was a lawyer, I'd be getting like thrown in like, you know, you cannot say, I'd be in contempt all the time. You cannot say that, Miss Oriani. The fuck I can't. Suds, you do incredible work as, oh yes, veteran Ness. Thank you for your service. So I am elated that I am not at the mercy of, yeah. It's I mean, it's reasonable doubt. It's been lost on people. Let's see here. Hanks. Oh God, Hanks. Love it. Hank's gaslighting methodology. That's so funny. 999. Thank you so much. Question is, do you agree that Ann Taylor tiptoed through the AT&T argument? Well, because she needed to get the judge to say she can question Nick Balance. Yes. I think she wasn't. I think it was just about like, hey, this is a motion limine. We're not playing and showing our cards. I also think that they want bigger bang for their buck. And that's going to come down the road when, if things get exposed right now, there's a way to cure the problem, which would still put Brian Kober going to trial. So CAJMBT when judge says yes. Yeah. I think there was probably moments that Ann Taylor wants back. Who wouldn't? I mean, think about this though. Like you guys you're thinking on your toes. That's why you have to know your case inside and out. I mean, everything about your case inside and out. But he was misstating the record so many times. So Bluebird 711. Are we gonna go over that CW doc? I could hear you with CW doc. What's the CW doc? Am I missing a doc there? Goldie! Super sticker, $20. Thank you so much. What's the CW doc? Are you talking about Commonwealth doc? What's CW doc? I don't know. Is that in this case? Crime Land, Justice League of Channels, True Crime, Vine. Thank you so much. 666, really? Throwing up the devil on my ass. Dude, just to think that Amazon clicks, like, the world's totally changed. My AI is off the hook. Can you imagine if, like, can your AI get subpoenaed? That's going to be the next thing, that my AI gets subpoenaed. You have Ann's email? Depending on their cost, I would plan and a hotel to get mom and dad's out there for a face-to-face visit. Oh, yeah. Thank you, Lisa. Lisa loves Nike. Is that it? All right. No Adidas for you. $10 WB. What's good? Thank you for the $10 super sticker. Goalie B33 gifted 5 memberships. Cheers to whoever picked up a green card. CW. Wait, what was it? What was the CW? Sorry, I was looking at the other ones. Anybody know what the CW is? CW show Banfield on it. Oh, there's a show. There's a new doc. Oh, for fuck's sake, we couldn't do that. But geez, that's gonna be a train wreck. MRM. How do you know so much? It amazes me. I read a lot. I practice. Is this trial? I think it's starting in August 100. I think Judge Hippler just fucking talks a lot. You know, he talks a lot for the state. He talks a lot for the state. When have you ever heard him say something to say that this is how he thinks that the defense is thinking about something, or that this is how the defense is going to do something? I only hear him speaking on terms of what he thinks it's talking for the state. Isn't that wild? Is trial going to be live streamed? Yes. Just nonstop over here. I mean, he went at Cyray's throat, and I'm just surprised. Like, it's almost like something like this. Like you have the opportunity to call him out and bring him out to testify, right? To ask him the questions that you're asking Ann should be asked towards him. And he's like, as an officer of this court. That's like when a judge really wants to get like, you're an officer of this court. You have to say certain things. It's like, buddy, I don't know the shit. He does. Based off of what he has, he knows, he's saying these things. He's providing them to me. And what, like, but Hitler not calling him out, that tells me everything I ever need to know about Hitler. Hitler is literally going back like this, lounging like this, talking. I mean, he's just like, I feel like it's not a courtroom when he's acting like that. Shit, Bev has more courtroom decorum than he does. And I think Bev's wild. I think Hitler's going to regret that he didn't call Cyree. I would have nipped, if I was a judge, I would have nipped that shit in the butt right then and there, but I don't know. I just think he does a lot. I mean, I get that you read the documents when they're submitted, right? So you want to know what the fuck we're talking about, right? So you're reading them. And then I would have a list of the questions that I had from reading them, right? Already out. And then when something gets answered that I have a question of, I check it off. Okay. And then if I had a question that wasn't mentioned in the oral argument, I'm going to say, looking at my list, okay, hey, what about this? What about this? What about this? You know, his way is just fucking, I have no idea what his way is. So. We'll see. We'll see. Thanks again, guys. Appreciate you. Have a good night. I wanted to do this for 2 hours and 30 minutes. This is 4 hours. I got to go. Peace out, Girl Scouts. I'll see you guys back here tomorrow. The rest of the week will be good. Karen Reed kicks off. We got Bev's Bingo. We're giving out money every day on the hour. If you guys got Cash App, download it. Play bingo. Even if you don't know Karen Reed case, we will have bingo. So you can win money every hour. Bingo, Bev's Bingo. It's fun. This was great. Good. Hopefully it helped everybody understand some stuff. Remember, they're going to play the cards to their chest. So, but again, thanks guys so much. See you back soon. Thank you, moderators. Night, Freckle Gemini. There you are. Go get your freckle on. Peace.